Okay? So it seems to me that when someone does this, as far as I'm concerned, they ought to be locked up. We ought to throw the key away. And they ought to be sued for every penny they've got. That may not be much, but if people are in bankruptcy and they're in prison, trust me, it sends a chilling message to those who choose to offend. I can also tell you that if you've got situations in whether it be in a public school, which you've looked at on some of this material, or other places that are state or those that are protected today, then you ought to look at ways that we can make their superiors accountable as well. I'd be all in favor of that. Here's where my rub is. My rub is that the trial attorneys couldn't have done a better job of crafting these bills. To be able to come in and find a deep pocket to go sue and take their fee in the name of protecting children. How does suing a public school or the state or anyone else protect that child? The damage is done. All this is just a big payday for some people. If we want to go after the real problem, let's deal with the real problem. And that's going after the offenders themselves and putting them in prison. Let's look at their superiors who should have known. Why is that a concern of mine? People often talk about the government. Well, who is the government? Well, we're the ones who fund the government. All of us and all of our constituents fund the government through taxes. So if there's someone who's working, I don't care whether it's a school system, the state, a county, a municipality, coming after them as an entity for punitive damages, which aren't allowed in the state today, how does that fix the problem? Seems to me what it does is just rewards the attorneys that want to file the suits so that they can ensure that they're going to get paid, and it ultimately costs the taxpayer money. And oh, by the way, property taxpayers. Once again, property taxpayers get to pick up the tab. So we say, well, no, there's all these safeguards. There's all these safeguards here. So that won't happen. We need to trust the court system, don't we? Well, let me just tell you a story. I'm not making any judgments here. I'm just going to state some facts. I heard there's a guy out there, his name is Donald Trump. I've heard he's kind of got some scrapes with the law, like massive lawsuits filed against him. Some would argue they're maybe a little frivolous. I can tell you one in particular as a banker. When you have someone that files a lawsuit against you for offering a financial statement that you believe is the right numbers, and you're sued because, and no one was damaged, and you're being sued because you submitted a false financial statement, is the biggest crock of crap I've ever heard of. But nonetheless, he's in serious trouble. They're prepared to take his assets away from him in New York. So when you start thinking about, oh, this is no problem, we got all these safeguards, just trust the system. I don't trust the system. And that's why I will not be supporting these bills or this bill and these amendments, because I think we need to look at other remedies. Money isn't the answer, and that's what we're looking at here, is a money grab. Thank you, Mr. President.
Thank you, Senator Jacobson. Senator Holcroft, you're recognized to speak.
Thank you, Mr. President. I think there's a little bit of confusion out there exactly what bill we're talking about. I think we started the debate speaking about LB 325, which is actually Senator Duncan's bill, which is the one that did not come out of committee. So I think that was a lot of the initial debate was about whether or not we should be debating this bill because it didn't come out of committee. And then we've shifted over to LB 341, which is Senator Halloran's bill about the sexual assault in schools. And that one did come out of committee. I mean, that one was voted out. But I'd like to go back to LB 325 to talk a little bit more about that, Senator Dungan's bill. And there's no sexual assault issue there. It's just it opens up the state and political entities to lawsuit. And there's nothing listed there about sexual assault of children. It just opens up state and political entities, counties, cities to lawsuit. Does away with eminent domain. Now the premise there had to do with a prisoner who was killed while in the custody of the Department of Corrections, and there was some negligence there. But of course, the state is immune from lawsuit in that case, and so that's why Senator Dungan brought forward LB 325 to address that issue. So I take it, first of all, on the Judiciary Committee, we did hear 230 bills between last year and this year, 230, and we heard them all, and we exec on dozens, and we advanced a lot. But we did not advance 325, and I take it a little bit personally that when I make my vote in committee against a bill, I expect it to be honored, and I think we should honor the committee process. Otherwise, why do we have committees? And I take exception on Senator Erdman's statement that we passed hundreds of bills last session that did not get voted out of committee. We voted hundreds of bills in packages, and some Christmas tree packages where there were 20 and 30 bills, but all of those bills were advanced out of committees. So they were they were voted on in committee, and they were advanced to general file. So I would be interested in the list of hundreds of bills of the 291 that we passed last session that were not advanced out of committee. But let me turn back to LB 325. And one of the issues with debating a bill on final or on general file when you don't advance it from committee is there's no committee report. I mean, you cannot go to the website now and look at the committee report and see how members voted and who spoke for and against that particular bill at the hearing. But never fear, my staff on the ball, my legislative assistant, John Shipman, and my administrative assistant, Tiana Alm, were able to pull up my notes from February 24th, 2023. That's when we heard LB 325, was last February, over a year ago. Thank you, Mr. President. And at that hearing, there were two proponents. There were the trial lawyers, not surprising, and there was a victim. And the victim's case was extremely touching. I mean, it plucked at your heartstrings. But then the opponents were the Intergovernment Risk Management Association, the Nebraska Association of School Boards, the Attorney General, and the county officials, and also the county attorneys. And so with the remainder of my time, I'd like to read their statement since we don't have a committee report. So this one is from the National Association of County Officials. It says, "Dear Chairman Wayne, on behalf of the Nebraska Association of County Officials, we appreciate the opportunity to appear."
Time.
Thank you, Mr. President.
Thank you, Senator Holcroft. Senator Hughes, you're recognized to speak.
Thank you, Mr. President. I wanted to stand and speak on LB 25, specifically speaking about AM 3327. Prior to being in this wonderful new job that I have, I was on the Seward Public School Board. So I kind of wanted to speak to this coming from a school board perspective. So LB 25 with this amendment 3327, which is filed on this, could seriously impact all public entities, public schools included, regarding liability, and in a domino effect, it would make it difficult for public schools to obtain insurance coverage, or at the very least, it would increase the cost of insurance. I just wanted on a sidelight mention Senator Holcroft saying, I find it interesting that the trial attorneys support this, because guess what? That gives them more business, doesn't it? The bill addresses the liability of a public entity in the event of a sexual abuse or sexual assault claim. What the bill would do, if brought into law, would increase the liability and remove the current tort claim cap. So one, it completely subverts the Nebraska Political Subdivision Tort Claims Act and begins the further dissolution of sovereign immunity. This amendment also creates a new liability under a negligence standard that has not previously been recognized, meaning the political subdivision would be liable for the criminal acts of others, not just staff members, but outside parties like other students or visitors or even intruders to the school. This amendment is broad enough that a political subdivision could be liable for any sexual assault that occurs on its premises, no matter what time of day, whether it's on a playground or a gym. By removing sexual assault claims outside the Political Subdivision Tort Claims Act, it creates an inconsistency on how to bring tort claims against political subdivisions. Currently, there's a specific procedure to bring a claim against a political subdivision. This bill removes that procedure for a specific type of tort and gets rid of 54 years of precedent. This amendment also creates unequitable results. The statements of intent calls for equity for victims of sexual abuse. However, private parties cannot be liable, and private schools do not need to comply with Title IX. It is untrue to say that victims have no remedy for a sexual assault against a school district. They have a remedy, and the remedy is through Title IX, which prohibits sexual harassments of students by employees and students. This includes sexual assault. Section 1983 and Title IX do not have damage caps. This amendment will ultimately force taxpayers to pay for the actions of criminals and will cost taxpayers more money. It will allow more claims to be brought against political subdivisions and removes the damages caps, which opens political subdivisions to much larger judgments. In short, changing this law does not keep any kids safer. I'm just going to say that again. This law does not keep kids safer. Schools do not want to see these incidents occur, and that's why schools are very diligent in background checks of staff, visitors, and substitutes, as well as training their school staff on boundaries and having policies in place for boundaries. ALICAP schools have completed more than 134,000 training courses already this school year. Grooming, boundaries, sexual abuse, and sexual harassment, and duty to report are all courses among those trainings. Lastly, I would like to stress the importance of educating and encouraging students to see something, say something. The Safe to Help app, which the legislator supported, is a great step in helping students and schools be safe. And Senator Bozen did a handout everybody should have on their desk, it's in color, of that app. So thank yourselves, other senators, for support in this. This communication hub's a great effort in getting these type of concerns communicated to the right people so schools can address the concerns and prevent harm.
1 minute.
Thank you, Mr. President. Raising the liability of a school does not keep the school students any safer. And I had gotten one example emailed, and I just wanted to mention it. And this happened, this is this year for a situation in a public school. A high school student was convicted of a sexual assault last school year. The student moved into a new district, and the public school was told the student needed to be in school as either a condition of probation or while the court sought treatment options. This court directive put an offender who could offend again in a public school setting. The school did their best to provide proper supervision and had safety plans in place, but the school was obligated to educate the student and also has the duty to keep other students safe. According to this bill, if this offender reoffends, the school district will be liable for monetary damages for the actions of a student that in essence is in the school building by a court directive. According to this bill, the public school would be liable and with no tort claim cap.
Time.
Thank you, Mr. President.
Thank you, Senator Hughes. Senator Armendariz, you're recognized to speak.
Thank you, Mr. President. I'm really confused at what direction I would go on this bill. Personally, I would throw the book at anybody and everybody involved in anything like this going on. Professionally and here in this body, I am a fiduciary of the taxpayer. So that's where I'm getting a little conflicted, and I have asked Senator Wayne if he will answer some questions for me when it comes to the liability portion of this.
Senator Wayne, will you yield the question?
Of course.
Thank you, Senator Wayne. So we talked a little bit, and you gave me a comparison of a private school child, public school child. The private school child family can sue to full extent of the law and recover financial damages, correct?
Yes. Underneath the regular negligence standard, yes.
And the public school family cannot cover any financial damage?
They would have to have a higher burden, and it's harder, yes. But right now, under state law, it's barred. They would have to go under federal law.
So I want to focus on, because it's kind of a big animal, I want to focus on the state, since that's who I work for here. Would you agree the state is not actually some corporation, it's us?
Correct.
So we are financially liable if
it was a state employee or the political subdivision, yes.
So would you say a school district could sue the state as well?
No.
Or a student that is abused in a school could also sue the state, all the way up from the school, the city,
No.
the state?
No, because there's not a duty under an employment relationship there. So it would have to be that school district. There has to be an employment relationship in the course of their employment, and that duty has to arise from their employment. And the school district has to be negligence. So it would never, only people that would get to a state level are state employees like HHS or state patrol. Like we don't.
So if it's an employee that worked for the state directly?
Correct.
So not a public school?
No, a public school would be liable for public employees if they breach their duty in the process.
Okay, so then it would be the taxpayers of that public school?
Yes.
So that's where I'm conflicted, because the taxpayer of the public school is quite different than a parishioner at a church.
Yes, and that's why I said at the beginning of this, you can either focus on the government or the remedy for the student. And so for me, it's about the child. I want to make sure that child is whole, that they get as much as they can to fix that gap.
Yeah, I understand that. I understand that part. And I want to know, I guess I'm struggling with how we make the taxpayer financially liable for something they have very little, if any, control over.
We do that all the time.
But is it right to do that? Because if they don't have control over changing the problem,
but they do.
Why would we penalize
They
them?
do. The local school board, through elections and through policy and through everything else. We do that all the time here. So for example, if State Patrol is in a high pursuit, we have a $6 million judgment. We held ourselves liable because under strict liability, because we said, you should know when you're pursuing a criminal at high pursuit on the interstate or where else, there is an inherent risk. And by doing so, if it's a third party, we're going to pay for those damages. So at the state level, just think about that, Senator Armendariz. A third party walking down the street who gets hit by a state patrol person chasing after somebody, they are made whole. That kid who is child molested by a DHHS employee, not made whole.
I get that. I'm going to have a little bit of difference to you personally.
1 minute.
That money isn't going to make them whole for sure.
100%. But that's the only thing we have on the civil side.
I get that. So then in a private school, they are sued and the church goes bankrupt, they go away.
And that's
Parishioners can walk away. But if a public school gets sued, they don't go away. They, like you said, there's unlimited resources because they go to the taxpayer and just get them. There's no bankruptcy caused by this at all. The taxpayers just pay more.
So if you would like a cap, I have no problem on that either. Vote from here to select, give me a cap. We can sit down and holler and we can look at some cases that are out there and see what those are. We can put a cap on it.
I would prefer having a lot more control over the school district as the people that are paying for the school district, if we're going to be liable for what happens in that school district.
Time.
Thank you, Mr. President.
Thank you, Senator Armendariz and Senator Wayne. Senator Slama, you're recognized to speak.
Thank you, Mr. President. Good evening, colleagues. I do want to reset debate because I do feel like we're getting caught up on LB 341, which is the First Amendment up on LB 25, should we get there. However, my opposition to the bill, and I'm going to be very transparent about how I lay out what my strategy is. I just discussed this with Senator DeBoer, and I support the IPP because the baseline bill, we have a great AG's analysis on why LB 25 is unconstitutional. I will get back to reading that here in a second. And I will support, if there is a reconsider that needs to be filed, one of those, if that stops LB 25 from moving forward. However, I will vote and support LB 341. I filed a poll motion on it in committee. I'm completely in support of it. However, if we're gutting it and attaching it to a bill that was deemed unconstitutional and then prioritized, we're in a weird gray area when it comes to procedure. So I want to be entirely transparent about where I'm at. I fully anticipate we'll have the chance to get to LB 341 if this goes the full 8 hours. But for right now, I do want to get back to the AG's analysis of LB 25, which is the bill that we are debating right now. So when I left off last couple hours ago, I was just starting out on the analysis section of this AG's opinion requested by Senator Ibaugh. Analysis, Nebraska Constitution, Article 7, Section 5, the Penalties Clause provides with certain exceptions that all fines, penalties, and license money arising under the general laws of the state shall belong and be paid over to the counties respectively where the same may be levied or imposed. All such fines, penalties, and license money should be appropriated exclusively to use in support of the common schools in the respective subdivisions where the same may accrue. LB 25 would allow the award of punitive damages in civil actions with the damages treated as fines or penalties required to be distributed to the common schools as directed under Article 7, Section 5. Before addressing your questions related to the bill, we begin with a summary of the Nebraska Supreme Court's case law addressing the constitutionality of punitive damages. A, Nebraska case law addressing the constitutionality of punitive damages. The Nebraska Supreme Court has identified two separate bases for finding punitive damages unconstitutional under the Nebraska Constitution. The first is the Due Process Clause. The second is the Penalties Clause. We discuss each in turn. 1. The court's first recognition of punitive damages as a violation of the Due Process Clause. In Boyer v. Barr, the Nebraska Supreme Court considered whether punitive damages could be awarded in a civil action for assault and battery. The jury was instructed that if it found the defendant acted deliberately and maliciously, it could award punitive or exemplary damages in addition to compensating the plaintiff for the actual injury. The court noted that the adjudicated cases and conclusions of eminent tax writers of either this country or England were pretty evenly divided, both in numbers and weight of authority, and whether punitive or exemplary damages can be allowed in a civil action, and that this was the first time it had considered the question of punitive, vindictive, or exemplary damages. Discussing authorities from other jurisdictions disapproving the practice of awarding punitive damages in civil actions, the court approving the law as laid down in those cases found the jury instruction on punitive damages improper. While not expressly citing the Due Process Clause as the basis for its holding, the cases relied on by the court in Boyer included a New Hampshire Supreme Court decision rejecting punitive damages in civil actions to keep the civil and criminal process and practice distinct and separate.
1 minute.
Thank you, Mr. President. And characterizing such damages as destroying every constitutional safeguard within their reach. I'll come back to this opinion on a later turn on the mic. But I want to be clear with where I stand. LB 25 had an attorney general's opinion come back, calling it unconstitutional, and then it was prioritized. And now we're trying to gut it and add in 341. While I support 341 and will support it if it were to come up, I can't support the practice of prioritizing bills after they've had an unfavorable AG's opinion returned on them. And if LB 341 is the priority, and I understand that we had a debate similar to this last night, if LB 341 is the priority and not LB 25, LB 341 should have been the bill that was prioritized. Thank you, Mr. President.
Thank you, Senator Slama. Senator Koff, you're recognized to speak.
Thank you, Mr. President. I have a lot of questions about this, so I'm trying to play catch up and read through everything. I've been making a lot of notes about what's going on. I'm looking at 341, and when it talks about political subdivisions shall be liable, it says for money on account of personal injury or death. I would really rather, instead of people being able to sue for money, if the goal is to make a child whole, which the goal should always be to make that child whole, why aren't we suing for therapy? Why aren't we saying do what actually will help that child? Because as been pointed out a few times, a pile of cash to a trial attorney is not necessarily going to help that child. I think if we want to be serious about this, we look at it and say, what does a child who's been sexually abused need? Do they need therapy? Do they need to be moved to a different school? Do they need a change of surroundings? What is it that will help them the most? And then look at providing that, rather than saying, hey, there's a big public purse that are taxpayers. And when people think about that big public purse, they think that there's no limit. They don't think that it's going to affect them. But it's going to affect each and every taxpayer when we have this. I also have some questions about what happens when you say, you're not responsible financially for this. You, the perpetrator, are not going to be held liable. We're going to hold a third party liable for this. What happens when we remove that financial responsibility from the actual responsible party and put it on the public? Will we see more charges? Will we see more people saying, hey, guess what, this happened to me? Or will it make people more willing to say, hey, I could get away with stuff? Senator Wayne was exactly correct. It changes behavior when there is a lawsuit, but whose behavior do we actually need to change? I'm concerned about lowering the standards, figuring out exactly what happened and who's responsible. Again, when we talk about making kids whole, I don't think a pot of money is what's going to make them whole. I would much prefer to see this say that the school would be responsible, or the public entity. Maybe it's state employees. Maybe it's, you don't know who it is. But I would really prefer that it say, we will make them whole through therapy. I have some concerns about 341. One of the things that caught my eye was that we're looking at section 6. Criminal prosecution under this section is not required to maintain a civil action under the State Political Subdivision Child Sexual Abuse Liability Act. So what they're saying is, even if you haven't been found criminally liable, civil is a different standard. And I have concerns with that. I think that's, the last thing I want to say is the time limits, having no time limitation. That's setting a pretty wide bar. That starts getting into decades. How do you possibly plan for that? So again, I'm listening to all of the discussion, trying to read through all of the different bills that are attached. I'm surprised that I'm just surprised at how the process has gone as far as getting these bills out and put together. Thank you, Mr. President. So I will continue listening. Thank you. I leave my time.
Thank you, Senator Koff. Senator McKinney, you're recognized to speak.
Question.
Question has been called. Do I see 5 hands? I do. The question is, shall debate cease? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
13 ayes, 8 nays to cease debate, Mr. President.
Debate does cease. Senator Boston, you're recognized to close. Debate does not cease, excuse me. Senator Boston, you're recognized to speak.
Thank you, Mr. President. I have somehow misplaced my, you're in luck, I found it. Okay. So a couple people have brought up that they're confused about what we're voting on and where we are and what we're doing here. So there are 3 amendments, substantive amendments, that are filed to LB 25. None of those were filed by me. Senator Wayne filed all 3 of those, and focusing on one, but this isn't about just one bill. Senator Slama tried to explain that as well. So this is a bill that has, it's LB 25, that has a filing on it based on an attorney general's opinion that it is unconstitutional. There are 2 additional bills. So it's not just one bill, it's 3 bills, all of which were filed by the same individual. So there was some discussion, and I did a handout on the efforts that schools are making, because I do support victims, and I do think that we have an obligation that if we're going to send our kids to schools, we need to have teachers be in the best place possible to identify potential sexual assault, to hit it head on when there is a problem, to report it, and to have it absolutely, there are no excuses, and I agree. And my position is this bill will not change the efforts that they are making. The question here is whether or not this bill will divert more public funds to civil litigation, and whether or not that's an effective means of reducing any sort of bad actors or assaults, or potentially increase safety or helping potential future victims. This isn't going to reduce the occurrence or frequency of assault at schools, because public entities are already taking proactive measures to avoid criminal assaults and remedial measures when they occur. And again, they are not doing this because of potential lawsuits. They are doing this because they are teachers, they are humans, they are moms, they are dads, they are aunts and uncles and individuals who care about kids, who care about raising the next generation, and they don't want these things to happen. Subjecting public entities to duplicative state law litigation isn't likely to make the public entity operation different. Every budget hit to a public entity is going to result in less money to adequately staff and supervise and hire quality employees. It will mean less things like cameras. It will mean more things like isolation in jail cells and prisons. It will result in less training. It will result in no additional ability to protect kids and inmates. It will just result in less money to do more. The notion of hitting them in the pocketbook to prompt change works for private businesses, but not public entities. Let me say that again, because everybody here is under the impression that if you can do it to a private business, why should the school be any different? Because hitting a private business in the pocketbook does motivate change. But Senator Armendariz is correct. Hitting a public entity, thank you, Mr. President. Hitting a public entity just results in higher taxes. It won't do the fundamental changes that you are articulating need to be made. If the issue is teachers aren't getting enough training on bullying or on whatever the issue that you may have, and it may be different for all 49 of us, then we should be bringing laws that address those issues. I will support those laws, and I have. But allowing political entities to bear the burden of things that we wish were different, and we all agree should be different, isn't going to do it. Accountability already does exist in the federal law remedy for any case where a public entity turned a blind eye or ignored a clear path to preventing an assault. There is no cap, there is no limit to a federal Section 1983 claim. They can be brought in either state or federal court, and you have the ability to recover your attorney's
Time.
fees. Thank you, Mr. President.
Thank you, Senator Boston. Senator DeKay, you're recognized to speak.
Thank you, Mr. President. I'd like to be on record to say that myself and probably the other 48 members of this body want to protect children from abuse. I'm sure we are all on the same page on this issue. Right now, I'm probably leaning in opposition to LB 25 if all of the proposed amendments get attached. I get where Senator Wayne is coming from when it comes to trying to help victims of some of these crimes. A concern of mine, which may need more explanation, is that we are trying to bring back a bill that the AG pretty much said was much constitutionally suspect. I guess I will be listening to more on that, and would Senator Wayne yield to some questions?
Senator Wayne, would you yield to a question?
Yes.
Thank you, Senator Wayne. I have several questions, and I'll do them in 3 different bullets. Number 1, how many states have what LB 341 does in their statutes? And if so, do you know how recent their statutes were changed to allow what you're proposing?
Thank you. Most states don't have the exact language, but most states, actually, almost all states, allow you to sue the political subdivision if there is a sexual assault and it's in relationship. Our statute, and actually federally, you can sue too. We copied the language exactly from the federally. When I say we, the Political Subdivision Act and the State Claims Act, our Supreme Court had a different ruling than every other Supreme Court. So a lot of states have the ability to sue.
Thank
And I want to clarify something. I fixed the constitutional issue in the amendment. The constitutional amendment is due process, and I'll be real quick because it's a short time, but the due process comes down to 3 things. Notice, you have to specifically plead, opportunity to be heard, which is a jury and judge, and a separate trial for punitive damages, or a separate proceeding for punitive damages in front of somebody who is neutral. That is the federal requirement for due process, and you can ask Senator Boston if nobody believes me. That is the state requirement for due process. That is fixed in my amendment.
All right, thank you. How many states, and switching gears just a little bit, how many states have what LB 320 does in their statute? And do you know how recent their statutes? Same question.
Same question. All states you can sue if there's a duty of care underneath the State Tort Claims Act, and we violate that duty. Our ruling by the Supreme Court was an anomaly.
Okay, and with what you're proposing in AM 3329, could you explain how those statutes would work in?
3229 is the punitive damage part. That was actually a statute taken directly from Oklahoma. I did increase the caps. We are 1 in 4 state in the country that doesn't allow punitive damages. So 46 other states allow punitive damages. And somehow insurance companies still work there. Somehow people work there, and the state has not went bankrupt. Thank you.
Okay, thank you, Senator Wayne. I just, some of the things that have mulled through my mind, I'd like to know who would be liable if a school kicks a can or a bad player down the road after an incident, however serious or minor it might be, not be reported on a permanent record. Who would be responsible for that? Would that be the unknowing new school that hired that person, or the old school that for whatever reason failed to report it? And I do like what Senator Cal said about therapy. Maybe the schools would be responsible. Thank you, Mr. President. Maybe the schools would be responsible for that. And I'd like to have the satisfaction of knowing that the perpetrators of these crimes are put away for as long as we can put them away. Thank you.
Thank you, Senator DeKay and Senator Wayne. Senator Linehan, you're recognized to speak.
Thank you, Mr. President. I've got a bunch of articles from newspapers since I've been in the legislature laying on my desk. I am going to quote from one. It's written by Joe Dacre and Emily Nitcher and Jeffrey Robb. It was a huge investigation the Omaha World Herald did after a horrendous incident in Omaha with abuse of children at a public school. There is no single central database containing complete real-time records of such misconduct. Records that exist are spread across several different databases from several different state agencies. I bet if we pass this law, we get a database. We pass laws all the time to deter criminal activity. Senator Holcroft had a bill today where we increase, I think it was today, I can't really tell, like all of us, it's like we're here 24 hours all the time. I think it was today, we increased penalties if somebody killed an unborn child. Why do we do that? Because we think if we do that, behaviors will change. The idea that everybody in the world can get sued, but we can't sue a public entity because it's taxpayers' money? Really? Because a child is getting abused and we can't sue? Would Senator Wayne yield to a question?
Will Senator Wayne yield to a question?
Senator Wayne, I have a child in a private school. Let's say you have a child in a public school. My child gets sexually abused. Can I sue the private school?
Yes.
Can I sue the church that is associated with that private school?
Yes.
Can you sue your public school?
No.
What would be the difference?
We make sure we protect the elected and connected and those who can afford. But the school districts who are, particularly in my area, who are maybe low income and they can't afford to go to a public school and maybe can't afford an attorney are left out of luck.
So, thank you, Senator Wayne. I also heard on the floor tonight that, oh my goodness, these could go back decades. Absolutely, they should. I'm a Catholic. Our church screwed up. It's embarrassing and horrific. And we're getting sued, and we should be getting sued. Now we're sitting here, though, and saying, oh, if you're public school, you shouldn't get sued. And from the lobby that this would cost hundreds of millions of dollars, well, that could scare us all to death. How big is this problem? And don't tell me that if we had tougher rules and they might get sued, their behavior wouldn't improve. I've got all the stories here, but I don't even have to read them. I remember them. You've got a principal that left Kansas, came to a school in Nebraska, had an affair with a 16-year-old. Tell me, guys, we're all grown-ups here. High school? How many people don't know what everybody's doing in high school? Like, how many questions do you have to ask before some 16-year-old that may not actually be involved in the situation knows about it? Every kid in high school knows everything.
1 minute.
It is silly to say that we can't be better than this. It's just silly. And if we're going to hold other institutions liable, we should hold ourselves, the taxpayers, school boards, the principals, the superintendents, the teachers liable. Thank you, Mr. President.
Thank you, Senator Linehan and Senator Wayne. Senator Wayne, you're recognized to speak.
Question. Call the House.
The question has been called. Do I see 5 hands? I do. The question is, shall debate cease? All those in favor? There's been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
19 ayes, 4 nays, place House under call, Mr. President.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Conrad, Senator Linehan, Senator Wayne, Senator Merman, Senator McDonald, Senator Reapy, Senator Hughes. The House is under call. Please check in. All unexcused members are now present. The question is, shall debate cease? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
29 ayes, 5 nays, cease debate, Mr. President.
Debate does cease. Senator Boston, you're recognized to close on your motion.
Thank you, Mr. President. I would ask for your green vote on the indefinitely postpone for LB 25. And with that, we will get to a vote.
Question before the body is the adoption of the motion to indefinitely postpone. All those in favor? There's been a request for a roll call in reverse order. Mr. Clerk?
Senator Wishart. Voting no. Senator Wayne. Voting no. Senator Walls. Voting no. Senator Von Gellern. Voting no. Senator Vargas. Voting no. Senator Slama. Voting yes. Senator Sanders. Voting no. Senator Reapy. Not voting. Senator Raybold. Senator Merman. Voting no. Senator Mosier. Yes. Voting yes. Senator Meyer. No. Voting no. Senator McKinney. Voting no. Senator McDonald. No. Voting no. Senator Lowe. Yes. Voting yes. Senator Lippincott. Voting yes. Senator Linehan. Voting no. Senator Kauth. Voting yes. Senator Jacobson. Yes. Voting yes. Senator Ibach. Senator Hunt. Senator Hughes. Voting yes. Senator Holcroft. Yes. Voting yes. Senator Hardin. Yes. Voting yes. Senator Hansen. Yes. Voting yes. Senator Holleran. No. Voting no. Senator Frederickson. Voting no. Senator Erdman. No. Voting no. Senator Dungan. No. Voting no. Senator Dover. Not voting. Senator Dorn.
No.
Voting no. Senator DeKay. Yes. Voting yes. Senator DeBoer. No. Voting no. Senator Day. Senator Conrad. No. Voting no. Senator Clements. Not voting. Senator Michaela Kavanaugh. Voting no. Senator John Kavanaugh. Voting no. Senator Brewer. Voting no. Senator Brandt. Voting yes. Senator Bostelman. Voting yes. Senator Bostar. Voting no. Senator Boston. Voting yes. Senator Blood. Voting no. Senator Ballard. Voting yes. Senator Armendariz. Voting yes. Senator Arch. Not voting. Senator Albright. Not voting. Senator Aguilar. Voting yes. Senator Boston. Voting no. Excuse me. Senator Boston not voting. Vote is 16 ayes, 23 nays, Mr. President, on the motion.
The motion is not successful. Raise the call. Mr. Clark?
Mr. President, Senator Boston moved to reconsider the vote just taken on MO 1281.
Senator Bosson, you're recognized to open on your motion.
I'm going to give up punitive damage. What else do you guys want?
Thank you, Mr. President. I rise asking for a reconsideration of the vote that was just taken. I have tried to spend the last several hours explaining why proceeding on LB 25 is a bad move for the state of Nebraska. I think there is a lot of misunderstanding about the role and the position that I'm taking on this, and that somehow by supporting LB 25, you are protecting children, and I disagree with that, and I'm happy to have those conversations. Sounds like we're going to continue having those conversations. It's my position that this bill does not accomplish that goal. I'm happy to talk about different ways to accomplish that goal, but if we vote yes on the reconsider, and we are successful on the motion to reconsider, then I will ask for another green vote on the motion to indefinitely postpone the bill and commit to having further conversations with the parties over the interim. So again, I'm asking for a green on the motion to reconsider, and I'm asking for a green on the indefinitely postpone. Thank you, Mr. President.
Thank you, Senator Bosson. Returning to the queue, Senator Ballard, you're recognized to speak.
Thank you, Mr. President. I'd like to yield my time to Senator Bosson.
Senator Bosson, you're yielded 450.
Thank you, Mr. President, and thank you, Senator Ballard. So going back to some of the issues, we'll start with LB 341. I'd like to read the letter that was offered at the hearing from Attorney General Jennifer Huxell on February 24th, 2023. She writes to say, I am an Assistant Attorney General and the Bureau Chief of the Civil Litigation Bureau in the Attorney General's office. Today I am testifying on behalf of the Nebraska Attorney General in opposition to LB 341. LB 341 presents a significant erosion of sovereign immunity protections, and I refer to my testimony for LB 325, which is the other bill that's an amendment to this bill, regarding the background and significance for sovereign immunity. LB 341 proposes to waive the state's sovereign immunity and create a new action against the state that operates completely outside the State Tort Claims Act for torts claims arising out of child sexual abuse. These would be actions to recover damages brought by victims injured by the intentional conduct of criminals. The policy question presented by LB 341 is whether those bad actors should be held responsible for their criminal behavior, or whether the financial responsibility to compensate victims should fall on Nebraska taxpayers. Whenever the legislature contemplates waiving the state's inherent immunity, it must be extremely cautious in doing so, because the ramifications will have a significant impact on the state, both in terms of the number of claims which will be brought against the state and the inherent costs to defend the claims, as well as taxpayer dollars, which must be appropriated by the legislature to pay judgments, settlements, and other costs which will result from these claims. First, it is very important to note that victims of child sexual abuse are not without a remedy if LB 341 is not advanced. A civil action may always be brought against the perpetrator of the abuse. In addition, victims of sexual abuse can currently bring a Section 1983 claim against a state employee who is alleged to have acted with, quote, deliberate indifference. Essentially, that they were aware of a substantial risk of serious harm and disregarded that risk, resulting in injury. A finding of deliberate indifference is more serious than a finding of simple negligence, the standard proposed by LB 341. It's the difference between observing danger and choosing to look the other way, which is the standard under Section 1983, versus applying hindsight to how things might have been handled better under the circumstances, which is the standard for negligence. If sovereign immunity is waived as proposed in LB 341, the state can then be sued for the actions of child sexual abusers, whether they were state employees or not. I've managed to lose the second page of that, so I'll have to come back to reading that letter. But to go back to what was discussed with the standard and the burden of proof here, under a section 1983, the plaintiff has to show that the defendant's conduct was reckless or callously indifferent. That's from a case, City of Canton versus Harris. Recklessly, intentionally, or with
1 minute.
gross, thank you, Mr. President, or with gross negligence, the deliberate indifference of those actions. Negligence is a different standard. The failure to exercise the level of care toward another person that a reasonable or prudent person would exercise under similar circumstances. So the standard here is under 1983, if the school knows or turned the other way when it was occurring, there are ways to hold them accountable. There are absolutely ways to hold them responsible, and you should do that. This is different. This bill would be drastically different than a Section 1983 allegation. Thank you, Mr. President.
Time. Thank you, Senator Bosson and Senator Ballard. Senator DeBoer, you're recognized to speak.
Question.
The question has been called. Do I see 5 hands? I do. The question is, shall debate cease? All those in favor vote aye. All those opposed vote nay. There has been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
17 ayes, 3 nays, place House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chambers, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Blood, Senator Jacobson, Senator Armendariz, Senator DeKay, Senator Bostar, Senator McDonald, Senator Hughes, Senator Arch. The House is under call. Please return to the chamber. Senator Bostar, Senator McDonald, the House is under call. Please return to the chamber. Senator Bostar, Senator McDonald, the House is under call. Please return to the chamber. All unexcused members are present. The question is, shall debate cease? There's been a request for a roll call vote. No request for roll call vote. Okay, all those in favor, the question is, shall debate cease? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
26 ayes, 13 nays, cease debate, Mr. President.
Debate does cease. Senator Boston, you're recognized to close on your motion. Senator Boston waves. The question is the motion to reconsider. All those in favor vote aye. All those opposed vote nay. Have all of you voted that care to? Mr. Clerk, record.
20 nays on the motion to reconsider.
The motion is not adopted. Erase the call. Mr. Clerk.
Mr. President, Legislative Bill 25, introduced by Senator Wayne, it's bill for inoculating the court, states finding defines terms and authorizes punitive damages prescribed. Bills read for the first time on January 5th of last year for the Judiciary Committee. That committee placed the bill on general file with committee amendments. There are additional amendments, Mr. President.
Senator Wayne, you're recognized to open on the committee amendment.
Don't I get to open on my bill first? Or did I already? Maybe I did. I can't remember. I've been in court all day morning. So look, everybody's caught up on punitive damages. Let me tell you why I introduced punitive damages. And Senator Brandt can confirm this. It was my attempt as a judiciary chair to figure out property tax relief. I believed every person should figure it out. And because it is a penalty, it is a fine, that means it goes to the local school district. Senator Brandt was here when I first introduced it on judiciary. That has been my basis. I did it this year because I thought every chair should figure that piece out. So when we have a special session on property tax relief, it'll come back. Here's why I say that. I am willing to forego that amendment, Mr. Clerk, that deals with the third amendment that deals with punitive damages. I will withdraw my amendment. If that's the issue, I will withdraw it. But if the real issue is we want to protect big government, then we just won't do anything and we'll just have a straight up and down vote on everything. But if people want to talk to me and figure out a compromise, if you think some school district is going to go bankrupt and you want to cap, let's come talk. Let's figure it out. I want to make that kid whole. That has been when Senator Halloran brought this bill, that has been my whole point. I prioritized it last year. That was the priority in my committee. I couldn't get it out. And with everything going on last year, I couldn't put the pressure of the body to say we should do something. That's what that final reading was when I got up and started talking about it. And we voted it and we got it out. 325 is not out. That is true. I want to have that debate. I want to understand why it's okay in a real life situation that I'm about to pass out on 325, where special needs kids was supposed to have one-to-one, the school district failed to do so, and that kid got assaulted. And how come that can't be liable for the school? That's what we're talking about. But if you want to have a conversation about caps, I have worked on every bill down here every year from general to select to figure it out. Now, the lobby's not going to like that I said that because most of them don't want caps. I get that. I am talking about making children whole. When we get to the Second Amendment with Dungan, and you'll talk about prisoners, it's broader than just prisoners. It's anywhere where there is notice given to a state or political subdivision and they choose to not act. They fail to not act. And you know who that usually involves? Besides prisoners, when they're overcrowded and double bunked and they tell them, hey, I'm going to kill this guy if you don't remove him, and they don't do anything about it and the person dies. It involves children. It involves workplace sexual harassment policies. It involves those kind of institutions that just say, I'm turning a blind eye. And when you talk about 1983, it has to be a policy. It has to be some kind of culture. It is bigger than just the one action. And Senator Boslin will admit it is a higher burden. So Senator Slama pointed out to Senator Ballard, small business might have a problem. Here's the crazy part. Senator Ballard gets sued under the regular negligence standard. Private institutions get sued under regular negligence standards. Under Senator Boslin's theory, we have to have a heightened burden because they're a public institution. That is choosing big government. That is choosing government protection over making people whole. I wish I could mandate 100% therapy. But you know what the argument will be when I say we're going to mandate therapy? Which therapist? The $1,000 therapist or the $500 therapist? We're still back into the same argument of cost. Civil suits, honestly, you can't demand them to say you have to choose this therapist. You have to do, what happens is a jury sits down or a judge and they look at all the evidence. And that judge says, here's my past medical expenses. I'm going to make you whole on that. You have to prove my future medical expenses are necessary and reasonably related to what happened. I have to prove that. And the only way I can prove that is with the expert. Minimum expert that I know costs $5,000 to $7,000. And guess what, colleagues? 90% of the attorneys won't do it. Why? Because some of them believe it's a conflict, that now you're invested in the case. Some of them just in all their retainer agreements say you are responsible for expert fees because they don't want to get into that. They don't want to be liable if the expert isn't paid. So you have to get an expert to calculate your damages in the future. We know what they are in the past, but even then you argue. You have one doctor who says, that knee injury, I'm talking personal injury, doesn't really go with what happened. So you have to bring in your doctor or an expert to say, no, it is reasonably related, and a jury decides, or a judge. But future, it always comes down to an expert. What will it cost to make this child whole? In workers' comp, we call it maximum improvement. This is it. It ain't gonna get no better. All that's expert driven. And what we did in workers' comp is we say, for your hand, here's how much you're actually gonna get. We make it very simple, but it's all cash based. It's all compensation. So I am saying today, right now, if you're so concerned about punitive damages, which is crazy to me because there have to be malice or grossly negligent. So that means they already did something wrong and the jury already found that. And then in a separate proceeding, the jury has to conclude, not just were they bad, but they were really bad and we're gonna punish them. And everybody, there is not one court case that I can find that says punitive damage is not a punishment or a penalty. And the purpose of punitive damages in every other state that has them is to deter that conduct. To deter that conduct. And it works. That's why every state has it except for us. And it's not that we don't have it. Go back and read the case and read the actual opinion. The first section on the penalty clause says, no, it's constitutional. Wayne's right. It goes to the school fund. So are you worried about property tax relief and local school funding? It goes to the school fund. So when that bad actor treats their employees really bad or does something grossly negligent, it isn't a run on the mill for the attorney, Senator Jacobson. It's a fine. It goes to the school district. The attorneys can't get it. It goes to the school district. There's no money by the attorney being made on that. But if you have that big a problem with it, I'll get rid of it. I'll get rid of it. Although I think punitive damages applies in many cases and we're trying to deter bad actors, that's your stumbling block? Fine. Then help me make kids be whole. You think, oh, for those who are saying, let's go after that actor and sue them. Let's take child sexual assault. They're in prison. They're judgment proof. You sue them, which they are still named on the lawsuit. They'll say you're liable for, we'll just throw a number out, $50,000. At the going rate of the state penitentiary, that child will be dead before they can collect $50,000. 50 cents a day. Well, how much is it, Senator McKinney? $1.20 a day. That's a long way to get to 50,000. So that kid can't even pay for their mental health therapy that will be required. But we're okay with that. So you can't run under emotions no more, because the next amendment is going to be lot hollerings. Then the following amendment is going to be 3/30/25. We can argue about why it's stuck in committee. That's fine. Maybe we should exec under and have one more vote right now. I'll bring my staff back. Because somebody's going to have to tell me publicly, when a school district takes a special needs kid and they know they're supposed to have one-to-one and just decide on this field trip, no, don't need one-to-one today, and that kid gets assaulted, no remedy. Go after that kid's parents. Well, let's hope that kid's parents is rich, that you can actually do. Let's hope they have some insurance that would be liable. But intentional torts, as Senator Slama already said, usually aren't covered by insurance, especially not covering punitive damages. But let's hope that it is. Let's hope that they have a big enough policy to pay for that, because the school district decided that day on a field trip, nah, we don't need to bring that extra employee. We're cool. Even though the IEP says it's required, they decided not to follow. We're okay with that too. So if the issue is punitive damages, I'm taking it off the market right now. Thank you, Mr. President.
Thank you, Senator Wayne. Senator Lowe, you're recognized to speak. Mr. Clerk, for items.
Mr. President, Senator Boston would move to bracket the bill until April 11th.
Senator Boston, you're recognized to open.
Thank you, Mr. President. I found some of the guidance for the schools in their sexual misconduct guidance policies that were adopted in 2020 as part of their effort to address these types of ongoing concerns. So I will go through some of that. I have a copy. It's kind of long, but I'm happy to make copies if people want it, or I'll have it at my desk and you're welcome to review it. It goes through and it talks about sexual misconduct, defines sexual misconduct, aiding and abetting, grooming, sexual conduct, sexual penetration, personal communication system, school employee, student, teacher, or intern, and certified educator. It then goes on through the federal prohibition on aiding and abetting, defines what all that is. It further articulates that all teachers at the school are mandatory reporters, and what steps they have to take under that requirement in those laws. The next section goes through the required school district policy. Nebraska law now requires all public, private, non-denominational, or parochial schools to adopt a policy addressing the professional boundaries between students and school employees before June 30th, 2021. It then gives the outline for what the policy must include, several requirements that they have to meet. The next section goes through criminal statute, creating the offense of sexual abuse by a school employee. So that's a new law that went into effect November 14th, 2020 by this legislature. Offense is sexual abuse by a school employee. Some of you were probably here and recall passing that bill. Then goes on to talk about the guidelines for best practices for administrators in conducting an investigation into an alleged sexual misconduct. Has 4 pages on that. Then goes through and talks about red flags, things teachers should be aware of and look for when acting in their professional capacity at the school. Then goes through the Title IX requirements that the school has to comply with, and also provides links to 4 different links for further information and resources. This is their policy that they have. These are the guidelines that they are adopting in an effort to address these concerns, and I think any implication that they have not done so or are not doing everything they can the implication here is that we have teachers and administrators that are sexually abusing or grooming children, and that we're okay with that if we don't want this bill. And that's just such a mischaracterization of what this is. I am 100% on board with holding those perpetrators accountable, and when the school has acted with deliberate indifference and they knew or they should have known and they still didn't do something to protect that child, that's not what I'm standing up here and saying that they shouldn't be held accountable for. But the reality here is that we are telling them that there is nothing that they could do more, and we're still saying, but we still want to be able to sue you and hold you accountable and say that you shoulda, woulda, coulda, and you didn't. And that's just not true. When you read these guidelines and you go through and you think about the number of hours that teachers are putting in for continuing education and ongoing training, the requirements that the school has, the protocols that they have, to imply that they are just willy-nilly ignoring these red flags it's crazy. I mean, it is just not the reality of what the schools are or have been doing to keep our kids safe. I would encourage you to review these. I'm happy to, as I said, I'm happy to share them. There's also several of the terms are defined in statute. Several of the requirements are criminal penalties in the statutes for individuals who are bad actors. And I am, again, not standing here and telling you that I condone sexual assault of children in school, and I take issue with anyone who wants to tell you otherwise. Please come see me if you have those beliefs. That is not what this is. This will not fix a problem that the schools are saying, tell us what we need to do. I mean, do we want to say, okay, the only solution to this is that kids should never use the restrooms in their public schools because that's where most sexual assaults happen? If you want to go to the bathroom during the school day, you have to go all the way home? I mean, is that the solution here? They're working hard to educate our kids, and we're making it more and more. We're attacking them from a perspective of you're not doing enough, and we're not telling them what they're not doing enough of. I still maintain that we've got several motions on here, some of which are still in committee, and I do take issue with that. No matter how many times people try to bully me into saying that that's not a problem, we have a process. That bill was held up to a vote. It did not pass out of committee, and instead of going through the process to do a poll motion, we just added it to a bill. And for the purposes of, now we're talking about pulling the bill. I don't understand exactly where we're going with that. I may have missed some of the discussion on that while I was looking at other things, but I am asking for your green vote on the bracket motion on I guess it'd be on the amendment 440 at this point. So thank you, Mr. President.
Thank you, Senator Bosson. Senator Lowe, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Holdcroft.
Senator Holdcroft, you yielded 450.
Thank you, Mr. President. Thank you, Senator Lowe. And again, I'm speaking on, continuing my debate on LB 325. And again, to kind of bring us up to speed, I know if as Senator Wayne just outlined, his sequence would be to bring up first LB 341, which is Senator Halloran's bill about being able to sue political entities for sexual assault of a child. And keep in mind, that's not just the school board. It is political entities. So if somehow there's fault found at the county level or the city level or the state level, they can also be sued under LB 341. But the one I would like to continue to talk about is LB 325, which would be the second bill that Senator Wayne would bring up, and that is the Senator Duncan bill. And that one really is based on an incident that happened in our prisons where we had an inmate who was killed, and there was some neglect on the part of the corrections. And so it does the same thing, though. It opens up our political entities to being sued at the state level, at the county level, at the city level, at the school board level. And so it really, 341 limits it essentially to a sexual assault of a child, but really 325 really opens it up to just essentially proving neglect. So 325 is still in committee. The hearing for it was held on February 24th, 2023. So well over a year ago. There is no committee statement on 325 because we didn't vote it out of committee. And so you don't see that. As I mentioned earlier, the proponents for 325 at the hearing were the trial attorneys and one victim. The opponents were the Intergovernment Risk Management Association, the school boards, the attorney general, county officials, and also the county attorneys. So I'd like to read some of the testimony that we had at the hearing. My first reading is from the Nebraska Association of County Officials. And keep in mind, this is LB 325. It was about a state issue, really, an incarcerated individual who was killed while under custody of a state. But the way the bill is written, it opens up all political entities, whether it's state, county, city. It says, Dear Chairman Wayne, on behalf of the Nebraska Association of County Officials, we appreciate the opportunity to appear before you in opposition to LB 325, which would expand the scope of liability to counties beyond what has ever been permitted in Nebraska. It would allow claims to proceed when the harm caused by an intentional tort is a proximate result of the failure of a political subdivision or an employee of the political subdivision to exercise reasonable care to either a controlled person over whom it has taken charge or protect a person who is in the political subdivision's care, custody, or control.
1 minute.
Thank you, Mr. President, from harm caused by a non-employee actor. The legislation has proclaimed its intent under the Political Subdivision Tort Claims Act in that it provides in part, no political subdivisions shall be liable for the torts of its officers, agents, or employees, and that no suit shall be maintained against such political subdivision or its officers, agents, or employees on any tort claim except to the extent and only to the extent provided by the Political Subdivisions Tort Claims Act. The legislature further declares that it is its intent and purpose through this enactment to provide uniform procedures for the bringing of tort claims against all political subdivisions, whether engaging in governmental or proprietary functions, and that the procedures provided by the act shall be used. Thank you, Mr. President.
Thank you, Senator Holcroft and Senator Lowe. Senator Erdman, you're recognized to speak.
Question.
The question has been called. Do I see 5 hands? I do. The question is, shall debate cease? All those in favor vote aye. There's been a request to place House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
15 ayes, 5 nays, place House under call, Mr. President.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Decay, Senator Frederickson, check in. Senator Lippincott, check in. Senator Slama, Senator Vargas, check in. Senator Hansen, Senator Dover, and Senator Bostar, the House is under call. Please return to the chamber. Senator Hansen, please return to the chamber. The House is under call. All unexcused members are now present. The question is, shall debate cease? There's been a request for a roll call vote in reverse order. Mr. Clerk, please record, or please do the roll call.
Senator Wishart. Voting yes. Senator Wayne. Voting yes. Senator Walls. Voting yes. Senator Von Gillern. Voting yes. Senator Vargas. Voting yes. Senator Slama. Voting no. Senator Sanders. Voting yes. Senator Reapy. Voting no. Senator Raybold. Senator Merman. Voting yes. Senator Mosier. Voting no. Senator Meyer. Voting yes. Senator McKinney. Voting yes. Senator McDonald. Voting yes. Senator Lowe. Voting no. Senator Lippincott. Voting no. Senator Linehan. Voting yes. Senator Kauth. Voting no. Senator Jacobson. Voting no. Senator Ibach. Senator Hunt. Senator Hughes. Voting no. Senator Holcroft. Voting no. Senator Hardin. Voting no. Senator Hansen. Not voting. Senator Holleran. Voting yes. Senator Frederickson. Voting yes. Senator Erdman. Voting no. Senator Dungan. Voting yes. Senator Dover. Voting no. Senator Dorn. Voting no. Senator Decay. Voting no. Senator DeBoer. Voting yes. Senator Conrad. Senator Day. Senator Conrad. Voting yes. Senator Clements. Voting no. Senator Michaela Kavanaugh. Voting yes. Senator John Kavanaugh. Voting yes. Senator Brewer. Voting yes. Senator Brandt. Voting no. Senator Bostelman. Voting no. Senator Bostar. Voting yes. Senator Boston. Voting no. Senator Blood. Voting yes. Senator Ballard. Voting no. Senator Armendariz. Voting no. Senator Arch. Not voting. Senator Albright. Voting no. Senator Aguilar. Senator Urban voting yes. Vote is 22 ayes, 20 nays, Mr. President, on the motion to cease debate.
Debate does not cease. Returning to the queue, Senator Holcroft. I raise a call. Senator Holdcroft, you're recognized to speak.
Thank you, Mr. President. I'll continue my reading of the testimony. And again, this is from the Nebraska Association of County Officials speaking against LB 325. And it says, continues, under common law prior to the adoption of the PSTCA, which is the Political Subdivisions Tort Claims Act, the court explained, this court long ago adopted the traditional common law view that a public entity engaged in governmental activities is not liable for negligence. Immunity has been based upon a public policy which subordinates mere private interests to the welfare of the general public. I think it's worth repeating. This is from the court. The court long ago adopted the traditional common law view that a public entity engaged in governmental activities is not liable for negligence. Immunity has been based upon a public policy which subordinates mere private interests to the welfare of the general public. It continues, not long after the Brown case was decided, the PSTCA was adopted in 1969. The State Tort Claims Act and the Political Tort Claims Act were the result of an interim study committee created by the legislature. Both acts were patterned after Iowa statutes and the Federal Tort Claims Act. In Weber versus Anderson, 187 Nebraska 9, which appears to be the first case decided by the Nebraska Supreme Court after the legislature adopted the PSTCA in 1969, the court addressed the intentional tort exemption by stating, in part, it is quite apparent that this court has not wiped out the full scope of the doctrine of governmental immunity. It has attempted only to eliminate government immunity in certain areas, and then only until such time as the legislature occupies the field. We are therefore faced with the problem whether or not the abrogation of the doctrine of governmental immunity should be extended to actions for false arrest, false imprisonment, and libel and slander. We conclude that governmental immunity should be and is a defense to these types of claims. We are influenced by the fact that this is the proper public policy to be adopted because of the enactment in 1969 by the legislature of a Political Subdivisions Tort Claims Act prohibiting tort claims except in the extent and only to the extent provided by this act. Through enactment of the PSTCA and the State Tort Claims Act, the legislature has allowed a limited waiver of sovereign immunity with respect to some, but not all, types of tort claims. Both the STCA and the PSTCA expressly exempt certain claims from the limited waiver of sovereign immunity. We ask that you not expand the current exemptions under PSTCA as LB 325 would do by significantly weakening the original intent of the international tort exemption under the PSTCA and create significantly heightened litigation exposure and costs for governmental entities such as counties. We encourage you to oppose LB 325 by voting to indefinitely postpone LB 325. Thank you for your consideration of these comments, and it's signed by Elaine, who's Elaine Menzel, legal counsel. And I'll give back to the president my remaining time. Thank you.
Thank you, Senator Holdcroft and Senator Lowe. Senator Jacobson, you're recognized to speak. Senator Jacobson, you're recognized to speak.
Thank you, Mr. President. Well, I think we're continuing to try to talk about whether there's some kind of middle ground here. Clearly from the vote you see on the board is that this is a very divisive issue. And if we're talking about moving the bill in its entirety, that's really a problem. I will tell you from my standpoint, punitive damages are a game changer. That absolutely cannot happen. I'll fight tooth and nail on punitive damages. I think I start looking at Senator Halloran's bill. There might be some pieces in there that we could potentially look at with caps and limiting it who could be sued. But I still believe that the challenge still comes back to really fixing the problem as opposed to suing people, as we've talked before. Yes, when this child is damaged, we need to be able to try to find help for them, which is not necessarily money, but more counseling. And sometimes money might be the worst thing for them after what they've been through. And recognizing that could also lead to abuse of alcohol and drugs, and now they have the money to pay for it. What we're really focused on, I think, is getting counseling for these kids and getting the perpetrators locked up, and potentially the supervisors of those people being fired. But we've talked about this before, that if you're a private entity, we talked a lot about parochial schools, private schools versus public schools. If you're a private school, I'll guarantee you, go to any private school, look at those parents that are there pitching in, helping on everything, fully engaged in what they're doing. Now, they have a real vested interest in what they're doing. I'm not saying that the public schools don't, but I'm just saying that in a larger public school, being able to look at that large employment base and to have one bad actor or two bad actors, or worse yet, or also go to any other political subdivision. What if it happens with the Parks and Rec person at your city? City's not going to get any of those punitive damages. How are they going to pay for it? Well, in many cases, they're not paying for it. We are. And does it really solve the problem? If we still have to deal with the problem with how do we now try to make it whole with the kid, in addition to how do we try to dissuade others from doing this same thing? So I think that's what we've got to get worked out here. If there's anything that's going to be moving forward, we've got to significantly skinny down this bill. And Senator Wayne, I've had a conversation with him. I think he's open to negotiating something that we can agree to, and I think that would be good. I think we need to get a lot closer to have what this framework would look like. And then if it were to move forward, that we would skinny this down significantly before it would go to select, with an understanding of what the other changes have to be once it gets to select, if it's going to be refiled again. So that's what I'm working on right now. But I don't want to, I'm not on judiciary. I've not been involved in this fight initially. Senator Bosson, I respect immensely, and I really want to hear what she has to say and what her concerns are going to be as we move forward. Same thing with Senator Holdcroft. These are people that Senator Holdcroft voted against the bill. Senator Bosson was a P&V on the hearing. So I think I want to weigh heavily into what their thoughts are. But at the end of the day, we're talking about some pretty serious steps in terms of breaching this veil of immunity. And we better do that with our eyes wide open. And I'm not sure we are doing our best work here at 8:12 in the evening after a late night last night and a long day today. So those are what my concerns are right now. Thank you, Mr. President.
Thank you, Senator Jacobson. Senator McKinney, you're recognized to speak.
Thank you, Mr. President. I oppose the bracket motion. I support the committee amendment, and I support LB 25. And Senator Jacobson, I am on the Judiciary Committee, so I think my voice matters as well, not just the people that oppose this bill. And it's very interesting. I think there are a lot of people who have kids in this body. There are a lot of parents in this body. And I would ask you the question, if your kid was assaulted in school and your only remedy was to be able to, and you wanted a remedy, and you weren't a parent that was well off, and your kid was dealing with trauma and you couldn't afford therapy, and your kid was dealing with it and you couldn't afford it, but you wanted some type of way to pay for that type of therapy to help your kid deal with that trauma, and you wanted to seek some type of remedy to hold somebody accountable, a show of hands, who would want to hold the schools accountable? It's very sad that a lot of parents in here wouldn't want to hold the schools accountable to get their kids help if they were sexually assaulted in school. It is crazy. It is honestly, it's shameful. My daughter turns 14 next week, and thankfully we'll be done. She turns 14 on the 14th, actually. And my nephew turned 4 today on the 4th. So, but honestly, we're talking about kids today. We're talking about important topics. And if the schools go bankrupt, if the counties go bankrupt, if the state goes bankrupt because kids are being assaulted and we're trying to help them out and help kids out because they're dealing with trauma, then the state and the counties and the schools deserve to go bankrupt because they're hiring people who shouldn't be hired. And that's the truth. Why are we trying to protect ourselves from accountability because people are being hired that shouldn't be hired? Let's be honest here. That is a problem. We're talking about protecting kids. It's been a bunch of bills this year about protecting kids from reading books. It's been a bunch of bills about protecting kids since I've been in this building. It's been a bunch of bills about protecting victims. We have discussions about victims all the times. I introduce bills about changing the criminal justice system, and the first conversations I get is, Terrell or Senator McKinney, what about the victims? You got to think about the victims. Well, what about the victims of sexual assault? What about the kids that are sexually assaulted? Let's think about them. I don't care about the money. The money shouldn't matter. It's protecting the kids. And if the floodgates open, they deserve to be open because the kids need protection. And it is illogical to me that people stand up and say no to this. Honestly, and people stand up and say we should protect kids. It is super hypocritical that people try to pass bills this year to say, oh, we want to protect kids from this, and that, and you should support this bill because you should want to protect kids, but they're saying no to this bill or these bills or these type of bills. You're being hypocrites.
1 minute.
And that's the honest truth, and it's sad. A lot of people have kids in here and grandkids in here, and if your grandkid was assaulted and you weren't well off and you lived in poverty and your grandkid was living with trauma and you wanted to get them counseling and help, are you just not going to get them help because you can't afford it and you can't sue the schools? This is sad, bro. This is really sad, honestly. This might be the saddest debate we had since I've been in the legislature. And we always talk about protecting victims and protecting kids. This is the saddest debate we've had since I've been in the body. Thank you.
Thank you, Senator McKinney. Senator Vargas, you're recognized to speak.
Thank you very much. I echo a lot of my colleagues' sentiments here. Senator McKinney, you know, part of the reason I'm frustrated with part of the dialogue is hearing one of the rationale behind opposing this being that it's going to increase property taxes, when it was very abundantly clear by Senator Wayne that, one, the burden of proof is higher and would be higher. Two, nothing is automatic. still needs to be, they need to be held liable, they need to be proven liable, and that we're talking about abuse of children, and that there's an opposition to allowing accountability to exist within the system, and also allowing punitive damages, which I support as well, because it's going to be a cost. It's going to be an increase in property taxes for a school. Well, that's ridiculous. Many of us in the past years, which includes Senator Halloran, worked on bills to try to increase some of the penalties for grooming and sexual assault. And part of the reason is we kept hearing these stories. We kept hearing these incredibly awful stories and cases. And the issue being that there is no way, hearing some of my colleagues talk about, well, let's just pay for mental health, when we don't hold that standard with private entities. The point is there needs to be a way to be able to hold an entity accountable. That's the point. And to be able to prove it is not a certainty. The cases that we're talking about, or cases that are currently right now could be happening, are some of the worst cases you can ever imagine. And we're talking about whether or not the accountability can be served. Same accountability that could be provided for a private entity, or in the case that Senator Linehan, the question she was asking, for private schools, couldn't be held accountable to public schools. It's appalling that the rationale that's being used against this is completely void of accountability for people that have gone through abuse. And I commend Senator Wayne because he's already said he would remove the punitive damages. And if the body was going to entrust him to move it forward, they would remove the bracket motion and move forward and see if there's something that can happen. We did that this morning with the firefighters bill. I understand some people are completely against that component, but if he's willing to take that part off, I don't understand what we're debating. And this is somebody, I'm speaking for myself as a former teacher and as a former school board member. I still believe that accountability should be held to any public or private school or entity, and that the burden of proof and the damages need to be in law.
1 minute.
So colleagues, I rise in support of LB 25. I rise in support of the amendment. I rise opposed to the bracket motion. This is about accountability. This is about making sure that victims of crime have a process for being able to get some punitive damages, and that's one component of this. And as you heard from some of the other bills, which I support, that are part of this, we have a responsibility to do something about this. And if rationale is talking about windfalls for lawyers, that this is going to increase property taxes, and that's your rationale against providing accountability for victims of sexual assault or abuse, victims of crimes, I think we have to look at ourselves in the mirror and think differently about fairness in the process.
Thank you, Senator Vargas. Senator Albright, you're recognized to speak.
Thank you, Mr. President. I'm not rising to call the question. I can't even believe how many times the question was called on the floor tonight. And this is not funny. This is a very serious issue that every one of us that are lined up in the queue should have an opportunity to talk about. We're talking about our schools in this situation and our children. I couldn't even get 3 extra votes to pass LB 441 when they sexualize our children in ways that we don't even want to know about. And we don't care about that. But we're going to stand here tonight and not really understand what we're talking about. I'm not an attorney. There's 3 different things they want to do. We have people that are serving on the Judiciary Committee that are trying to help us understand this. But if there's already in law, the 1983, 42 USC 1983, whatever the heck that's supposed to mean, I'm not an attorney, but what I am is a concerned grandparent of 15 grandbabies that are going to be worried. I have to worry when we drop them off at school if it's a safe haven. You know, I'm serving on education. My eyes have been opened in ways that I never thought they could be. And serving 8 years in this legislation, it has just turned my head upside down, knowing what can happen in situations like they have in the schools. We had a bill this year that they're asking for peer review shouldn't be a part of this. It shouldn't be peer reviewed whether somebody should lose their license to teach because they've done something so egregious to our children in the classroom. They should be in front of a court of law. And should you hold the school boards responsible? Heck, the school board doesn't even know what's happened because nobody tells them it's happened. It's all done behind the scenes and do whatever you want to do. But when I have a book that's in my office right now, I should have gone down to get it, but I don't have a key to it. I'm sure I could get the security to unlock it for me. But there's a book down there that talks about school teachers or coaches that are still coaching today because they don't take it to the next level and find out if they're guilty or not because they're just going through the process in the school themselves. Folks, that's not how it works. These people that have done something, and most parents, if they don't even have the ability to get and retain an attorney, they're not going to go the extra mile. But that child's going to suffer with whatever happened to them, however they were being sexualized. But things like this are very serious, and we need to decide as a state legislature whether we need to cover this or not. So I'm trying to decide right now, am I voting for this or am I voting against it? You know, with this, the conversation we had about Senator Halloran, I went up to him and I said, hey, if I get 441 across the finish line, you should put your bill on mine. But you know what? We all have to understand what's already in law and what we can do and what we can't do. But this is crazy tonight that we're going to play with our kids by calling the questions so we are not allowed to find out what's really in this so that we can try to understand it, because not many of us have a law degree. And those that have it are trying to stand up and talk about it. And those who sit on the Judiciary Committee, whether they understood it or not, just like I'm trying to understand it, are not for LB 25. You know, this is really serious business that we conduct here
1 minute.
on a daily basis. And if we can't take the time to try to understand why we shouldn't be voting for it or why we should be and help us make those decisions, everybody's in the corners, you know, laughing and having a good old time tonight. But this is a serious bill. And we need to understand what we're going to be doing with it and why. Are we going to vote for all 3 of these amendments? Heck, we don't have time because we're not taking the time to understand them. I'm really frustrated right now, and I'd like a little bit of decorum in the room so that we can get through this. Thank you, Mr. President.
Thank you, Senator Albright. Senator Wayne, you're recognized to speak.
Thank you, Mr. President. So there's no more confusion. Punitive damages off the table. So when I talked about property tax relief and school fund, that is strictly for punitive damages. So ignore that concept right now. It's gone. All right. I am trying, because I know that I'm looking at Brent. The reason why I know punitive damages is going to come back when we have our special session. It is property tax relief, so I'm comfortable waiting on that. So let's explain a little bit about how this works. If something happens at a school with a teacher or a sheriff, there has to be a duty that is established. So Senator Albright talked about 1983 claims. I'm going to talk a little bit about negligence claims, tell you the difference. It is not the same standard. I don't care what anybody says. Case law is clear. It is more than just negligence. It is a higher burden of proof. Now, what that means is it's still clear and convincing, but you have to prove more than just negligence. Negligence is a reasonable standard. What that means is, let's do the notice idea. So if somebody tells me my kid is getting bullied and beat up, et cetera, I sit down, inform the principal, inform the school district, this is going on, and they just say, we're not doing nothing. That's negligence. That's a problem. They should try to do something. That's how you get there. If somebody just walks up to my daughter and punches her, I have no claim against the school district unless the teacher knew and the teacher breached her duty in that situation by not informing the principal or not doing anything to control the classroom. So what that means is if they're out on the playground and there's nobody supervising the playground and the school district or the school knows these kids are going at it, but we're going to leave them unattended, that is a problem, especially if a kid gets sexually assaulted by the teacher. That's bill number 1. So they have to know something or been on notice of something. It isn't simply just this idea, it's regular negligence. You have to have a duty. It isn't a free-for-all lawsuit. And the headlines write themselves, people. If you get up here and say the sky is falling and school districts are going to go completely broke, that might be okay if it's that big of a problem in that school district. Think about that. That might be okay, because something's really wrong if there is that many sexual assaults and the school district knew about it and didn't do anything about it. Think about that. And you're worried about frivolous lawsuits? No, first of all, an attorney has an ethical obligation not to file frivolous lawsuits, and the client can be required on a frivolous lawsuit to pay damages of their attorney on a frivolous lawsuit. That is the law. If it is a frivolous lawsuit and deemed frivolous, my clients can be held liable for the attorney fees of somebody else. That is why you don't file frivolous lawsuits. Period. What I'm kind of just dumbfounded is we're worried about an institution that knows about something and fails to act.
1 minute.
Make it make sense. We handed out on an example of Senator Duncan's bill that involves a real life case, where the school district failed to protect a kid with special needs because they thought, we don't need extra supervision, even though it's required in the child's IEP. But you want them to go to a higher burden, do it harder, make it more difficult for that kid to recover. We're better than this. We are better than this. And you say, sue the individual, hold them accountable. Sue what? The para who didn't go? She's making he's making $40,000 a year. The medical bills for the broken arm are $100,000. Sue who? The school failed to act. Why should that parent or grandparent be stuck paying that medical bill? Thank you, Mr. President.
Thank you, Senator Wayne. Senator Conrad, you're recognized to speak.
Thank you, Mr. President. Good evening, colleagues. I rise in opposition to the bracket motion and in support of the underlying legislation and committee amendment. We've talked about these issues at great length during this session, and it's good to have them on the board now so we have an opportunity to take action. But I want to inject a couple of pieces into the record here. as a mom and as a civil rights lawyer. So number one, and I know my colleagues who have children and grandchildren in this body care deeply, deeply about their families, as of course I do as well. And I'd ask you to think about if it was your kids in this situation, and think about if it was your family in this situation. And so before I get into the lawyering, I want to focus on a little mom-splaining here, I think, because I had a chance to watch some of the debate before I got a chance to get in the queue, and I'm going to tell you that it is not a good look emanating from this Nebraska legislature tonight. And it's pretty sad to see a lot of moms that I respect on this floor fighting against families and kids getting justice. The other thing that I want to make clear is some of my colleagues have danced around the different, what's distinguishable or analogous for private schools and public schools. So let me just unpack that quickly. So in private schools, if a kid gets hurt or if there's an issue like this, there is no extra level of protection. So what we're talking about is giving access to justice in the public schools like they have in the private schools. The reason the courthouse door is closed is because the government has given itself extra protection. Okay, that's why it works that way. The government has given itself extra protection that doesn't exist for your private schools. That's why there's more accountability there in the courts, okay? The other thing, and I know that not everybody's a lawyer, and some of these issues are complex, and it's actually beneficial that not everybody's a lawyer so that we can look at these from a lot of different angles. But I've heard thoughtful, compassionate colleagues say, the remedy isn't money, the remedy is counseling. Friends, I know your heart's in the right place, but let me be clear. The civil justice system's remedy is money. It's money. You're awarded damages. You're not awarded counseling. That's not how it works. It's up to the individual or the family to utilize that award for counseling or medical needs or lost wages or pain and suffering or whatever it might be. So I want to just make that point clear. You can have a legitimate opposition to this bill, but the opposition can't exist on a remedy that doesn't exist. The criminal justice system, you have a loss of liberty. The civil justice system is based on compensation to make you whole for wrongs, whether that's private parties in a public entity. That's the crux of the civil justice system. So I just want to make sure that people know about that. I also just want to be clear that this argument that we should just cede authority and punt to the federal courts is a weird argument for state legislators to make. We don't just cede authority and punt to the federal government.
1 minute.
The issue is opening the state courthouse doors as they were meant to be opened, righting the wrong by the legal fiction and the court decisions, making sure people have access to justice closer to their home. That's more responsive. That's quicker. That covers more issues. 1983 cases are not for negligence. They are for civil rights violations. There has to be a constitutional violation or nexus to walk into federal court on 1983. It's not just generally available when somebody gets hurt, okay? We can have our own opinions, but we can't have our own facts. Those are basic facts about litigation and jurisprudence. The other thing, and I'm probably going to run out of time, is I really want to push back against this greedy lawyers mantra that's emanating on the floor. Look no further.
Time.
Oh, okay.
Thank you, Senator Conrad. Senator Kauf, you're recognized to speak.
Thank you, Mr. President. May I ask Senator Conrad a question?
Senator Conrad, will you yield to a question?
Yes.
Would you like to finish your statement?
Oh, you're so kind, Senator Cal. Thank you. Thank you. I'll be very quick. I know I'm on your time.
You're fine.
My point is this. There was a story in the Journal-Star front page just in the last week or so. It talked about a sex discrimination case employees brought against the city of Lincoln. And it talked about how it took years for the case to move through the courts. It talked about how the city attorneys have a full department of attorneys to protect the city, and they hired a huge corporate firm. And a plaintiff's law firm that was small couldn't take on other cases because they were working full time on the sex discrimination cases. They weren't bringing revenue in the door. So yeah, they did successfully settle for their client years later, but they're backfilling wages that they weren't bringing in for years when they're up against the city with unlimited attorneys who also hired corporate attorneys. So I want people to get real about what's happening in the dynamics of this case. Senator Cal, thank you for your graciousness in allowing me to finish that thread. I really appreciate it.
You're very welcome. And kind of selfish on my part, like I said, I'm listening to all of this. I very much appreciate your comments and finishing that up. I appreciate that Senator Wayne sat down and tried to walk me through all of this. It's incredibly complicated, very complex, a lot of moving pieces. I was pleased that he said the punitive part is off the table. That seems to simplify things just a little bit. I still have a lot of questions about how it's going to impact the taxpayer, city government, what are the unintended consequences? I feel like I am going to need to be reading through a lot of things, talk a lot more. We've got 3 and a little bit hours left for a whole lot more conversation on that. But I am very, very pleased with the conversations that have been being had. Everyone seems to be interested in educating each other, and I appreciate that because I need a whole lot of that right now on this issue. I have a lot of questions still. So I will actually relinquish my time and get back to let Senator DeBoer take over. Actually, do you want my time too? Sure. I will yield my time to Senator DeBoer.
Senator DeBoer, you're yielded 2:20.
Thank you, Mr. President. I am sufficiently chastened, Senator Albright. We were trying to, I think, get through the bracket motions and the other motions so that we could get to the individual separate amendments, but not calling the question. Okay, so one thing that I think maybe I can help explain is the State Tort Claims Act writ large. So there is a principle in common law that is really kind of what all of this is about. We inherited this from days of yore, and yes, I said of yore on the microphone. And that is a principle called sovereign immunity, which is that there's a king, it's good to be the king, and the king doesn't let you sue the king. Y'all, we're the king now. So the principle of law is that you cannot sue the sovereign, in this case, the state, unless we say you can. So the states have state tort claims acts that say you can't sue us except in this room.
1 minute.
Colleagues, in this room, we decided to say, in some cases, you can sue us. In this room, our predecessors got together, I don't know who it was, I don't know how far back it was, and they said, if there is a city driver and they get in a car accident with you, and because of their negligence, you are injured, you can sue the state. You can sue the political subdivision. That's what our Tort Claims Acts say. If you are on city or state property and there's a slip and fall, people in this room got together and decided you can sue the state. You can sue the subdivision.
Time, and you are next in the queue, so you may continue, Senator DeBoer.
Thank you, Mr. President. We have the responsibility for deciding in which situations it is okay to sue the sovereign. That's us. What Senator Wayne and Senator Halloran are asking with LB 341 is that we say, like in the case of a slip and fall, like in the case of a car accident by a driver employed by the city, by the state, whoever, if there is negligence on the part of the state actor, let's say the car driver, you can sue us. What we're looking for here is if there is negligence on the part of the state actor, and as a result, your child gets sexually assaulted, we want to say, we'll let you sue us for that, just like slips and falls, just like a car accident. What we're trying to do is create that option so someone can go to the courthouse and ask for justice. Doesn't mean they get it. And by the way, you have to show in negligence, you have to show there was a duty. You have to show that the person you're suing breached that duty. You have to show that you have damages, and you have to show there is a causation, that there is causation between their breach of duty and your damages. Your damages have to be caused. And it's not like Senator Ballard sues my mom because I hit Senator Ballard and he says, if Wendy's mom hadn't given birth to her, then she couldn't have hit me. That's not the kind of causation we're talking about here. And this is a well-trod legal doctrine. Negligence is a well-trod legal doctrine. It says that the causation must be, we use the word proximate. That means it has to be foreseeable. It has to be close in time, not time, but it has to be close enough. It has to be the cause that is connected. So what we're saying is, we're asking our colleagues here in this room to say, if there is a duty to take care of a child, if there is a breach of that duty, if the breach of that duty caused, that close proximate caused damages to a child, we're asking you to stand up with us and say, in that situation, we recognize that we can be sued, like we do in these other cases. That's what we're asking for. If there is a business out there, if there is a private school, if there's a daycare, and a child is sexually assaulted in one of those businesses, we look for duty, we look for breach, we look for causation, and we look for damages. And that private entity, they can be sued because people in this room created a negligence statute that says for private entities, they can be sued under those circumstances. We created that.
1 minute.
What we're saying is, since we created that for other businesses, people, etc., let's create it now. We already say if you're hit by a city bus, we're going to take care of that because we understand. And this is where Senator Wayne has said, we'll put caps on it. If the worry is we're going to be out of money or something like that, or it's going to be extraordinary, let's put caps on it. We can put guardrails on these things. We're not. We just want to say that if there is a duty, a breach, causation, and damages for a child who's been sexually assaulted under our watch, that we give them the same opportunity to come to justice that we would give someone who was hit by a city bus driver. Thank you, Mr. President.
Thank you, Senator DeBoer. And Senator Koff. Senator Duncan, you're recognized to speak.
Thank you, Mr. President, and good evening, colleagues. I've not spoken really at all yet on this as I was waiting to get to the amendment that contains LB 325, which was the bill that I originally introduced and a lot of people have spoken about. But I felt compelled to get on the mic for at least a short period of time while we're talking to touch on a couple of things. One is I want to make sure that we're all very clear about what these potential proposed amendments do and what they don't do. These do not open up political subdivisions for any claim whatsoever. These do not blow up the Political Subdivision Torts Claim Act at all. In fact, LB 325, which is the bill that I brought that will be an amendment down the road here, doesn't change the law in any way, shape, or form except return us to what the law was, what the precedent was for decades. This is not a new concept. We didn't come up with this in a lab and think this would be a cool, fun thing to try to do in Nebraska and see if it works. This was the law of the land until a case was issued by the Nebraska Supreme Court in 2020. That case upended the precedent that we had for decades on whether or not some political subdivision, a school, could be held liable in the event that they failed to take care of the people that were in their care. And then an intentional tort or some bad act happens and they could have stopped it and didn't do it. When that case came down from the Supreme Court, there were cases pending that were working their way through the justice system that were dismissed because they were bound by the precedent of the Nebraska Supreme Court saying, gee, sorry, we were working our way through the system, but this case came down, so you're out of luck. A school district had a field trip for students with special needs. One of the students was known to be violent with the other students and had an individual education plan, an IEP, stating that the student always needed a paraeducator with them, always, at all times. The paraeducator was out for the day, and the school district did not bring in a substitute. The student was out. The student sexually assaulted another student with special needs while on the trip. Student with special needs was sexually assaulted on a trip when the school was in charge of them. That got brought to the courts, and that case against the school district was working its way through the courts when that Supreme Court opinion came down, upending the law, and the case was dismissed. There was no accountability. That family, that student, never had an opportunity to be made whole in that circumstance and have the school held accountable, despite the fact that the school had knowledge and the school failed to act. And it was a direct breach of their obligation to that special needs student. And in doing so, in failing to act, that student was sexually assaulted and nothing could be done for the family in the courts. I'm not okay with that. If you've paid attention in the legislature to me for quite some time, you know I love my public schools. We talk about it all the time. I love my public schools here in Lincoln. I love my public schools across the state. I still don't think they should be able to get away with that. If they fail to act and they have knowledge and they are in charge of a special needs student and they know darn well that if they don't do a certain thing, something bad's going to happen to that kid, and they still make the decision to not act, yes, they should be held liable. In what world?
1 minute.
Thank you, Mr. President. In what world do we just shrug and say, you know what? I thought about it. I contemplated the costs, and gosh, at the end of the day, it might be too much money. So, yeah, it's really sad. It's a really sad story that happened, but you're right. We checked the checkbooks, we balanced our ledgers, and we're worried about what that means at the end of the day. Accountability matters. These court cases matter. People deserve to have their day in court. People deserve to be made whole. Students deserve to know that if somebody fails to protect them, there's going to be recourse. So I encourage everybody to understand that is what we're talking about here. And when we get to Senator Halloran's bill, which is a great bill, I encourage people to vote for it. When we get to 325, I would encourage you to vote for it because it matters not just to Nebraska, but it matters to the students who are affected by that. Thank you, Mr. President.
Thank you, Senator Duncan. Senator Linehan, you're recognized to speak.
Thank you, Mr. President. I would like to ask if Senator Wayne would yield some questions.
Senator Wayne, will you yield to some questions?
Yes.
Senator Wayne, I know you've had sidebars and discussions all over the floor, and hopefully people are paying attention, whether they're here on the floor or back in wherever they are in the building. What exactly would you walk away with from this? This was a committee priority, right?
Personal priority.
Personal priority. But you are the chairman of the committee, right?
Yes.
What could you walk away with tonight and feel like we've made the place better, though we didn't get everything you had in your bill?
So we already scrapped punitive damages. I'm willing to keep that out. So what I would do is on Senator Holleran's bill, and I'm hoping Senator Holleran nods his head and says it's okay, I would take what currently is the medical malpractice cap. So that means doctors who get sued is 2.5 million. That is what we would cap a child sexual assault at, 2.5. I would take Senator Duncan's bill, roll it in, but keep a cap on political subdivisions of 1 million. That is the current law, by the way. That's the current law, 1 million. So this idea that a school district is going to go broke, the most they can get is 1 million. Child sexual assault will be 2.5. And again, that has to be proven out. And against my side, I am willing to cap what attorneys can make at 25%. My justification of that is Medicare reimbursements. When your clients have Medicare and you're trying to figure out claims, our state law caps attorney fees at 25%. I will be perfectly honest, my side won't like it, your side not gonna like it, and that usually tells me we have a pretty good deal, that we're in the middle. I'm willing to take that. The point of it is I'm trying to get kids who have been sexually assaulted help. I'm trying to make sure that when a special need kid has an IEP and the district just fails to act and they get broken arms and broken legs, that there is a way for that parent to at least get their medical bill paid and pain and suffering of any future medical bills and pain and suffering for that child. So that, I believe that's easily, if you think about medical costs, 4 surgeries, you're over $1 million anyway. So we're capping it. I'm willing to do that. And if you think this is a run on attorney fees, let me tell you, most contingency agreements have a 33%, and if you go to trial, it's a 40%. My attorneys will not like what I just said about 25%. And why is that important? It's important what Senator Conrad said. These cases take years. And you are spending all that time, years, and let's say at a very, very low rate of $100, which an hour, which is probably not even, you get that for a court-appointed cases, at least in Omaha. Think about 2 years before you get to a jury, how many hours you put in. A cap of $1 million and 25% at 250,000, you've literally went through all of that because you're gonna have expert fees, you're behind. You're taking this because you think it's the right thing to do at that point. Just like you take the Medicare cases, and when you do that and you're fighting with the federal government, CMS on Medicare reimbursement, you're doing it because you think it's the right thing to do for those individuals, but you're not gonna do it for free. I will tell you, talk to the lobby on my side, they're gonna probably be, I don't like this at all, especially the attorney fees part. I'm willing to move. I am negotiating right now against myself because I think it's the right thing to do for kids.
So Senator Wayne.
1 minute.
Senator Wayne, is this only about minors?
No, it's not 100. No, his bill, the first bill, is only about children's sexual assault, only about. Senator Duncan's bill covers the other part where not just kids, but if a state has a duty, like, again, I bring up sexual harassment policies, things like that, where you are informing the actor, this is a problem, and they fail to correct it or fail to act. They fail to protect you. You have to be and it's not a free-for-all. It has to be in the care of or in the custody of. So it isn't just like, when I say workplace, it isn't just 2 workers. There has to be some kind of care of, some kind of duty to help this person. So it could be special needs adults. It could be people in prison. It could be children. Yes, our most vulnerable. We are trying to help.
Thank you, Senator Wayne.
Thank you, Senator Linehan and Senator Wayne. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. Good evening again. I told this to Senator DeBoer a few minutes ago. I don't think I've heard a better description, a better explanation on what we're trying to do. She spoke that in a language that I think all of us could comprehend, and I appreciate that. I want to speak a moment just briefly about calling the question. Senator Albright, I didn't do that to make fun or to be lighthearted about this. I did that because I wanted to get by the priority motions so that we could get to the amendments. We spent a lot of time talking about this bill, not much time talking about the real bills. And that's what happens when you do an IPP or a bracket. So the goal was to get us to the place where we had the amendments up that we were talking about so we could have a full discussion about those. So if you were offended by me calling the question, it was not my intention to offend anyone. It was my intention to bring the discussion to what actually the bill means. And I think we've done that. I think Senator Wayne, I know Senator Wayne has taken the concerns that the people have on this floor to heart. You've noticed he has, as he said, negotiated against himself. He's taken away punitive damages. He's done and would do whatever is necessary to make this work. Senator Wayne is a negotiator. He understands how you make laws better, and he's trying to do that. So Senator Wayne has offered those things to us, I think, in a very honest and straightforward opinion. And I believe when he says, I'm protecting children, I want to protect children, I believe him. I hope you do as well. So we're going to get ready to vote here sometime before midnight, I would assume. So if you have not made a decision about how to vote on this bill, I think there's been plenty of evidence given for you to draw a common sense conclusion as to what the answer is. That's what we do here when we make good legislation. We thoroughly discuss it. We consider all the avenues and the ideas, and we make adjustments. We've done exactly that tonight. So when we get ready to vote on this, keep in mind what we're trying to do is just bring these units of government into the same place the private sector is. And so if you don't think the government should have special protection, maybe the private sector should have the special protection that the government has. That's not what we're trying to do here. We're trying to make it the same. We're trying to protect children. We're trying to protect the most vulnerable. And I think that's what Senator Wayne has concluded in his comments. So we're going to vote for this. Thank you, sir. When you're ready to vote, please vote. Vote your conscience. And remember, we're protecting children. Thank you.
Thank you, Senator Erdman. Senator Holdcroft, you're recognized to speak.
Thank you, Mr. President. I've heard a couple of times people say that there's no recourse for the victims, and of course, I think we've mentioned a couple of times that they can be sued at the federal level. That's harder level of proof of burden, and they can be sued. You can go after the perpetrator at the state level, and my concern, if we open it up at the state level to go after schools and counties and the state, and you're worried about paying lawyer bills and everything else, court fees. Why would you go after the perpetrator? Because all the money is at the state, county, and city levels and school boards. So get a bigger bang for your buck. Forget about the perpetrator. Go after the where the money is. And of course, where the money is with the political entities. And where do they get their money? They get their money from you and me through property taxes. So all this work we're doing to try and reduce property taxes, I think would be for not much if we open this up for the suit, for lawsuit in this case. Now, again, Senator Wayne has eliminated LB 25. I mean, as far as the punitive damage goes, we're really concentrating on LB 341, which is minors, and he's putting caps on that. And LB 325, which is Senator Duncan's bill, really opens it up, as has been already stated, for lawsuit for through adult anytime the political entity is negligent in the protection of someone under their care. So 325 again, to beat a dead horse, is still in committee. We don't have a committee report. And as I mentioned, we had at the hearing, and I don't know how many of you were at the hearing. I was, and I voted against the bill based on what I heard at the hearing. And so to continue my education for you on what occurred at the hearing, I would like to read a statement then that came from the Attorney General. And again, this was at the hearing, February 24th, 2023, so well over a year ago. Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Jennifer Huxell, and I am an Assistant Attorney General and the Bureau Chief of the Civil Litigation Bureau in the Attorney General's office. Today, I'm testifying on behalf of the Nebraska Attorney General in opposition to LB 325. LB 325 presents a significant erosion of sovereign immunity protections, resulting in additional exposure to the state of Nebraska. It is the duty of the Attorney General's office to defend claims brought against the state, and for the reasons explained below, we are opposed to the erosion presented in LB 325. Sovereign immunity is a fundamental protection of taxpayers and is fundamental to the ongoing operation of our government. Claims against the government are paid by the taxpayers who fund the government. Long-standing principles of sovereign immunity stretching centuries and applying to all 50 states along with the federal government limit claims for damages against the government to only those specific circumstances where the legislature has made a policy determination that taxpayers should be financially responsible. Thank you, Mr. President, for the tortuous conduct of certain individuals. Current law does not permit a claim against the state where the claim arises out of assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel, slander, misrepresentation, deceit, or interference with contract rights. Nebraska revisions stat 81-8.219, that's the statute. These claims are often summarily referred to as intentional torts. But it is important to note that the list provided in statute is not exhaustive. Therefore, LB 325's general use of the term intentional torts, rather than listing the specific intentional torts waived, would expand the claims where sovereign immunity is waived. Thank you, Mr. President.
Thank you, Senator Holcroft. Senator Bosson, you're recognized to speak.
Thank you, Mr. President. I just want to provide some clarification here because we've talked about a lot of examples and the certainly the situation that Senator Duncan brought to our attention is obviously quite sad situation. But there is, I just want to be clear, when we say there is no remedy for that family, there wasn't a claim brought under a 1983 filing. So I don't know why that is. I don't know what the answer to that is, but it's my position that that case likely would have and should have been successful under a 1983 claim and probably also under a Title IX claim. So when we say that there's no remedy or that that family has no opportunity, it is true that it is a tragic situation, but I don't want someone to walk away from here and say we have no remedies, because as I've tried repeatedly to point out, we have a remedy for victims of sexual abuse under Section 1983, and no matter how many times that we say that can only be brought in federal court, I am telling you that we have concurrent jurisdiction and we can file those claims in state courts as well. And as Senator Conrad pointed out, if that's closer to home, you can file them there. You can file those claims against a state employee who is alleged to have acted with, quote, deliberate indifference. So when we talk about negligence, that's a standard, and when we talk about deliberate indifference, that's another standard. It is a more serious finding than simple negligence. The standard that is proposed in LB 25 and 341 and 325 is a negligence standard. What's in 1983 is a heightened sense because what you're suing for is different when it is a political subdivision. You are suing individuals as taxpayers as opposed to a business who is likely to be able to say, we can't do that anymore. That's obviously a bad act. We are going to either go bankrupt, as they should, or we're going to change our attitudes and do something different, make money doing something else. When you're suing a political subdivision, it's a different situation. The difference is between observing danger and choosing to look the other way under a Section 1983 claim versus applying hindsight to how things might have been handled better under the circumstances, which is a negligence standard. I earlier was reading a letter and couldn't find the second page, and I've now found it, so I will use this time to finish reading that. LB 341 therefore exposes the state and taxpayers to additional costs from the possibility of a judgment or verdict on these claims. To reiterate, this is the letter that was submitted at the hearing by the Assistant Attorney General. That letter is dated February 24th, 2023. So it goes on to say, LB 341 therefore exposes the state and taxpayers to additional costs from the possibility of a judgment or verdict on these claims, resulting in significant financial consequences to Nebraska's taxpayers for the actions of other bad actors. And if this passes, it will put state agencies in the same category as perpetrators by eliminating the statute of limitations for claims against those agencies based on the actions of non-state employees. This will make it more difficult for state agencies to timely investigate, thank you, Mr. President, maintain records and locate witnesses if claims are brought many years after the alleged incidents occurred. We haven't talked a lot about that, and perhaps we'll do that on our next time on the mic, but the statute of limitations in the bill that's being proposed is different than what the current statute of limitations is. So the bill would propose that the statute of limitations be 21 years of age plus 12 years. That ties into our last concern, which is that this legislative bill provides for these claims to proceed outside the existing procedural protections of the State Tort Claims Act. Historically, the legislature has been very specific in the manner in which it waives sovereign immunity and the procedures that must be followed. The State Tort Claims Act procedures apply to all other tort claims brought against the state. One of the policy benefits of the State Tort Claims Act is it allows the state an opportunity to investigate claims made against it prior to litigation.
Time.
Thank you.
Thank you, Senator Boss. And Senator Clemens, you're recognized to speak.
Thank you, Mr. President. I think it was good for Senator Wayne to come up with a number, because unlimited liability, who knows what that would be. But he was quoting a $2.5 million number, which I think would be per claim. And you could have many claims. And I'm sure if they did a fiscal note on that, that would exceed our A bill limit in our budget this year. But I still appreciated what Senator Boson said, that this bill still doesn't make a change to protect children. I think that's what she meant. And if Senator Boson would yield to a question.
Will Senator Boson yield to a question?
Yes, but I apologize. I didn't hear what the question was.
I think I heard you say this bill still doesn't make a change to protect the children from abuse. A sentence to that effect, was that part of it?
Well, if I said that, what I was intending to imply was that the issue here would result in litigation, certainly, and the child would have already experienced the incident.
Yeah, that's what I thought you meant.
Okay.
I'll yield my time to Senator Boson so she can complete that. Thank you.
Senator Boson, you yielded 320.
Thank you, Mr. President. Okay, so I'm going to finish reading this letter, hopefully here. Okay, so we were talking about the policy for State Tort Claims Act and that it allows the state an opportunity to investigate claims made against it prior to litigation and to proactively manage its risk. That was one of the things Senator Wayne was discussing, and what that means is you point out to them that there's a problem, they investigate that, it may get resolved through negotiations at that time. You can file a lawsuit if they are not responding in the way that you want, the political subdivision doesn't respond in a way you want. So that's what that, you have a year after that investigation period to file the claim, or 2 years, I believe. For example, the STCA requires that a claim be filed with the risk manager, giving the state notice of the potential claim and allowing the state an opportunity to investigate the claim, to pay the claim if appropriate, to determine whether the merits of the claim would be more appropriately resolved through the court system, and to potentially set aside reserves of state funds if payment by legislative appropriation appears possible. That was one of the bills we voted on a couple of weeks ago. LB 341 provides that these claims for child sexual abuse would operate outside the existing procedures of the State Tort Claims Act, which represents a departure from longstanding legislative practices for waivers of sovereign immunity. She goes on to say that they oppose that bill. So that is one of the individuals who came in and testified in opposition of LB 341. There were others. And I will continue looking for those here so that we are aware of who came in and on what grounds, but I don't have them right now. So, oh, yes, I do. So this is a letter that was submitted on behalf of the Nebraska Association of County Officials.
1 minute.
Thank you. Also dated February 23rd, 2023. It's a letter from Elaine Menzel, who is their legal counsel. Dear Chairman Wayne, on behalf of the Nebraska Association of County Officials, we appreciate the opportunity to appear before you in opposition, which would expand the scope of liability to counties beyond what has ever been permitted in Nebraska. It would allow claims to proceed under a newly created Political Subdivisions Child Sexual Abuse Liability Act. I'll finish the rest of this letter on my next time on the mic. Thank you, Mr. President.
Thank you, Senator Boson. Senator Holcroft, you're recognized to speak, and this is your third opportunity.
Thank you, Mr. President. You know, when I was assigned to the Judiciary Committee, I got some guidance of the two most critical things you need to protect on the committee was sovereign immunity and eminent domain. Those are the two things that were most important in the Judiciary Committee. And that's got me crosswise with two senators, both Senator Halloran and Senator Erdman, because both had priority bills, one having to do with sovereign immunity, which is the one we're debating now, and the other one with eminent domain. But I really, and I really appreciate what Senator Wayne has done to take out the punitive awards. That was really the most important thing, I think, and to neck down on LB 341 with caps. But it's still, to me, it's not enough. I mean, we're still crossing a line here. We're eroding our sovereign immunity. And so I would like to continue the testimony that we got from the Assistant Attorney General. She was talking about LB 320, I'm talking LB 325, which is Senator Duncan's bill, which is not, it not only applies to minors, but also anyone who's under the care of a political entity. They said, therefore, LB 325's general use of the term intentional torts, rather than listing the specific intentional torts waived, would expand the claims where sovereign immunity is waived far beyond those currently defined. Only the international intentional torts identified in current statute have been analyzed and decided by Nebraska courts. And this broader use of the phrase intentional torts will introduce a new analysis that has never existed in Nebraska case law. We have the same concern with regard to LB 325's introduction of a new legal analysis regarding whether the intentional tort is a proximate result of the failure of a state agency to exercise reasonable care to either control or protect persons over whom the state has taken charge or who are in the state's care, custody, or control. This is a new standard not previously defined by Nebraska case law, which may result in significant fluctuations and potentially inconsistent rulings by district court judges for many years to come. It will take time for these cases to make their way up through the district courts to the Nebraska Supreme Court for interpretation. In the meantime, it will fall upon the state to defend itself from this new category of potential judgments, and it will broaden the liability of the state beyond just the actions of state employees themselves. For example, by making the state potentially responsible for illegal acts by dangerous individuals who received long sentences for serious felony convictions. First, under LB 325, the state would likely lose the defense of sovereign immunity and be liable for claims brought by inmates alleging they were hurt by another inmate in a fight, possibly a fight they started. Claims brought by inmates alleging they have PTSD following a riot caused by the other inmates. Claims by committed patients who allege injury or property damage by other patients. Everything from broken glasses to broken radios to injuries sustained in mutual fights.
1 minute.
Thank you, Mr. President. Claims of inmates whose property is stolen by other inmates. Claims by community members and others that a foster child placed in the custody of DHHS harmed them or caused them property damage. Pursuant to current law, the state would most likely be granted immediate dismissal in the above scenarios based on sovereign immunity. LB 325, therefore, exposes the state and taxpayers to additional costs from the possibility of a judgment or verdict on these claims, resulting in significant financial consequences for the state and taxpayers. Second, and related to the first, permitting these actions exposes the state to significant litigation costs and expenses, even if the state is ultimately successful. Under LB 325.
Time.
Thank you, Mr. President.
Thank you, Senator Holcroft. Senator Koff, you're recognized to speak. Senator Koff. Senator Koff waves. Senator Hughes, you're recognized to speak.
Oh. Thank you, Chairman. Sorry, I was expecting to have a little bit more time, but I don't. So again, I speak to Rise on this, again, coming kind of from the school board side. And I wanted to read a little bit of the testimony that was presented on or in February in 2023 when Senator Halloran brought LB 341. And this statement was done by Jennifer Huxall, the Assistant Attorney General, Civil Litigation Bureau Chief, Nebraska Attorney General's Office. So I was just going to read it for the record. Good afternoon, Chairperson Wayne and members of the Judiciary Committee. My name is Jennifer Huxall, spells it. I'm Assistant Attorney General and the Bureau Chief of the Civil Litigation Bureau in the Attorney General's Office. Today I'm testifying on behalf of the Nebraska Attorney General in opposition to LB 341. As with LB 325, LB 341 presents a significant erosion of sovereign immunity protections, and I refer my testimony for LB 325 regarding the background and significance for sovereign immunity. At the outset, our office wants to make clear that we support the ability of sexual assault victims to be able to hold perpetrators to those crimes to account, and we appreciate Senator Halloran bringing this bill to highlight the importance of that right to those victims. Critically, those victims currently already have the ability to do just that. Victims can now bring a civil action against the perpetrator of the abuse. What LB 341 would do would be expand the scope of suits to the state. However, there too, victims of sexual abuse can currently bring a Section 1983 claim against a state employee who is alleged to have acted with deliberate indifference, essentially that they were aware of the substantial risk of serious harm, disregarded that risk, and that resulted in injury. A finding of deliberate indifference is more serious than a finding of simple negligence. The standard proposed by this LB. It's the difference between observing danger and choosing to look the other way, which is Section 1983, versus applying hindsight to how things might have been handled better under the circumstances, negligence. We would raise three concerns. First, LB 341 would potentially shift the responsibility to pay damages from the wrongdoer, the criminal or the perpetrator, to the state and its taxpayers. The policy question is not whether there should be a defendant held responsible. There currently is such an avenue, and that, this is on me, this is my statement, that avenue should be pursued if this happens. But rather, those bad actors should be held responsible for their criminal behavior, or whether the financial responsibility to compensate these victims should fall on Nebraska taxpayers. Second and related, LB 341 would expose the state and taxpayers to additional costs of litigation from having to defend the lawsuits, even if a judgment was not rendered against the state. Third, this bill provides for these claims to proceed outside the existing procedural protections of the State Tort Claims Act, the STCA. The STCA procedures apply to other tort claims brought against the state. One of the policy benefits of the STCA is that it allows the state an opportunity to investigate claims made against its prior litigation and to proactively manage its risk. For example, the STCA requires that a claim be filed with the risk manager, giving the state notice of the potential claim and allowing the state an opportunity to investigate the claim, to play the claim if appropriate, and to determine whether the merits of the claim would be more appropriately resolved through the court system, and to potentially set aside reserves of state funds if payment by legislative appropriation appears possible. LB 341 provides that these claims for child sexual abuse would operate, thank you, Mr. Chairman, outside the existing procedures of the STCA, which represents a departure from longstanding legislative practice for waivers of sovereign immunity. Then I was also going to read, there was a board member, school board member that came and sent in comments. Under current law, any claim made by us against the school for child sexual abuse would fall under the PSTCA. This act provides a financial cap of $1 million for liability claims made against school. LB 341 removes sovereign immunity provided by the PSTCA and therefore eliminates the liability cap for all political subdivisions. If passed, it could greatly increase the financial exposure to political subdivisions. And I'm just going to interject here. We are talking about, I had a conversation with somebody walking outside that, okay, this will not break schools. Schools will not go under from this, but it will cost schools more money, it will cost counties more money, and it will cost cities more money. And you know who's making that money? Insurance companies. And they will see this and be happy to increase their fees. Thank you.
Thank you, Senator Hughes. Senator Lowe, you're recognized to speak.
Thank you, Mr. President. I'm going to give Senator Holdcroft a break from reading some of the testimony that was done before the Judiciary Committee. Chairman Wayne and members of the Judiciary Committee, my name is Brandy Johnson. I serve as General Counsel for the Nebraska Intergovernmental Risk Management Association, or NIRMA. NIRMA is a self-insurance and risk management pool owned and operated by the 83 of our Nebraska counties. I'm here representing the county members of NIRMA in opposition of LB 325. I want to clarify at the outset that by statute, NIRMA is not an insurance company. It is a self-insurance and risk management pool. This means NIRMA member counties pool their taxpayer dollars together to pay claims. Over 50 years ago, our Tort Claims Acts were enacted, which provided sovereign immunity for public entities for certain kinds of claims. Our opposition to 325 is about preserving the Tort Claims Act because they are critical to NIRMA's mission of self-guarding taxpayer dollars. LB 325 seeks to erode the Tort Claims Act. Those efforts aren't new, and this particular bill seems to be in reaction to the 2020 Mosier versus State case decided by our Nebraska Supreme Court, but it is important to point out that Mosier didn't cause a new or major shift in the law. It only corrected a single inconsistency or outlier, Doe versus OPS, in a larger body of many years of case law. Sovereign immunity had applied to claims arising out of assault under the Tort Claims Act well before Mosier. For example, Jill B versus State. It is also worth noting that 6 of our 7 justices agreed to reach a sovereign immunity outcome in Mosier. In the court's subsequent Edwards versus Douglas case, the major point out that any expansion of the claims that can result in governmental liability necessarily involves the important public policy issue of the impact of the public fiscal. After all, protecting taxpayer funds from litigation exposure was part of the purpose of the passage of the Tort Claims Act in the first instance. Additionally, to the extent of LB 325, it is an effort to have legislature adopt the view of one dissenting justice from the Mosier case. The bill doesn't align with that dissent. It opens a far wider door of litigation. It would allow civil litigation whenever it is alleged that a government entity should have done more to control someone it has taken charge of from causing intentional harm, or whenever it is alleged that a governmental entity should have done more to prevent harm by a third party to someone in its care, custody, or control. So what kind of cases does this open the door as practical matter? In my litigation experience, by far the biggest category would be inmate on inmate violence cases. These are types of cases that have arisen in appellate case law several times during the nearly 3 years since Mosier case was decided in 2020. It would also encompass student-on-student and student-on-teacher violence harm caused to third persons and combative arrestees when law enforcement can't ensure complete security during an incident. But there is also an uncertainty. Thank you, Mr. President. About how to interpret LB 325 references to persons over whom a public entity has taken charge or who were in the public care, custody, or control. If the wording extends to those who enter a public building, LB 325 would require public entities to be monetarily liable for injuries caused by an active shooter in a public building. And does an employer take charge of its employees? I don't know what courts would conclude, but to suffice to say that the language leaves a lot of room for litigation over interpretation questions. In the vast majority of the cases that LB 325 would create, we are talking about adding a civil penalty for criminal behavior that would be paid by the taxpayer instead of the criminal. LB 325 would shift responsibility for the crime away from the perpetrator who directly
Time.
caused the harm. Thank you, Mr. President.
Thank you, Senator Lowe. Senator Bosselman, you're recognized to speak.
Thank you, Mr. President. Good evening, colleagues. Good evening, Nebraska. Senator Bosman had said something earlier on the mic that I wanted to talk about a little bit. She's off the floor right now. Hopefully she'll come back in just a few minutes and we can have that conversation. Specifically, what I want to talk about is I want to make sure I understand and everyone else understands the testimony that we're hearing or that's being read by certain people on the floor talks about immunity. And when I hear immunity and other people talking about it, to me, it means that immunity means there is nothing you can do. You have no recourse. There is no responsibility. There is nothing that you can do. And I don't think that's right. And Senator Bosman had said something earlier when she was on the mic that caught my attention. And I kind of go back to the time when I was on active duty because I worked in the claims office. So we did medical malpractice claims, we did failed tort claims, those type of things. And there's a process that you go through when you sue the government. So you file a claim first, and if the claim's denied, then you can sue. Or if you file a claim and there's no acknowledgement of time at a certain time, then you can sue. So I'll let Senator Bosman listen as I speak with what I'm saying, and then I'll ask her to respond here in just a few minutes. But my understanding with what I was hearing being discussed and talked about was if you're a private business, there's a different set of statutes, a different way which you can, if one of your employees, one of the people within your business causes harm or damage, you do have recourse because you can sue. There is a specific way that you can do that. When we talk about a political subdivision of schools, take it, the employees of that school, you don't necessarily, as the state Claims Tort Act says, is that if something happens to that, your recourse is to file a claim. That's what I want to talk to her about and make sure I understand. You can file a claim for what those damages, whatever it is for, and maybe Senator Boswick can explain that, is if it's for medical, it's for those, so you can file a claim. So then that entity would have an X amount of time, like you do on the federal side, to respond to that claim, to either pay it or deny it. If you deny it, then you have the ability to sue and recover. So what I think is being talked about here, and that's what I'm going to try to work through, is when people are talking about immunity, doesn't mean that there is no recovery and there is no course of action to be taken. There is a course of action taken. It's just different than when you're in private side. If you own a business in your private sector, you have a different course of action to take than if it's a school. So again, if something happens, it's a school, you file a claim gets paid or not, and if not, then you sue. So would Senator Bosman be willing to answer a question?
Senator Bosman, will you yield to a question?
Yes.
Senator Bosman, hopefully I tried to talk through my questions I have and my understanding, what I think I heard on how the difference is between you've been explained between a private business and say a school political subdivision on how you can file a claim or how you can sue. Were you able to kind of follow what I was talking about?
Yes, and that is what I recall you asking me earlier.
And was that fairly accurate? I mean, we don't have complete immunity, but there is a course of action you can take in that public school setting to where a claim can be filed.
1 minute.
And then their suit could be followed if it's denied.
Correct. So under Nebraska Revised Statutes, Chapter 81, Section 8209, that is the State Tort Claims Act. It explains its purpose, how one would comply with a filing under that. So that'll tell you how to walk through that process. Then if that claim, they could pay that claim out. They could come to a negotiation on it. They could deny it, and you can then proceed.
Thank you. So there is a financial recourse a person can go through. There's also a criminal side. So if there is a criminal side, meaning if a person that commits the act.
Correct.
That person can be criminally prosecuted. And then that entity then could have a file claim against it and then sued if it's not resolved, and if it's denied or it's not resolved, correct?
And that's what we.
Time.
Okay, yes.
Thank you, Senator Bosselman and Senator Bozen. Senator Erdman, you are recognized to speak, and this is your third and final time.
Thank you, Mr. President. I can't believe my third time already. So I wasn't going to speak again, but someone, how should I say this, aroused my curiosity by talking about eminent domain. And Senator Holcroft came here to protect sovereign immunity and eminent domain. I came here to try to fix our broken tax system and do something for the voters who sent me here to make their life better. I didn't come here to protect the government. I came here to make a difference in people's lives. So let me give you an example about our conversation with Senator Holcroft. I had an eminent domain bill that was going to ask whoever does the eminent domain to pay twice the value for ag land to make up for the lost revenue, and to pay replacement costs for any facility that the government was going to take. The fiscal note came in at $15 million, and Senator Holcroft said that's $7.5 million a year for what the government spends. And my question was, so if the government doesn't pay the $7.5 million, who does? The answer is the private landowner. So then the next question is, would you rather have the private landowner made whole and the government pay the $7.5 million, or have the landowner pay the $7.5 million? And by his vote, not voting my eminent domain bill out, we've seen what his decision was, and it was to protect the government. So saying I came here to protect eminent domain is a peculiar position to take. And as I said, I wasn't going to bring this up, but I couldn't resist after what he had said. I don't know how in the world that got into the conversation about what we're trying to discuss here, but it did. So Senator Wayne, as I said last time on the mic, he's trying to make an adjustment, several adjustments to make this work. And we talk about they still have the opportunity now under our current system to sue and all those things that are a remedy to their problems. Senator Rain is trying to fix that to make it more fair, open, and transparent, and easier for people to make that claim. So I haven't changed my position. I'm still for whatever Senator Wayne negotiates, and if he doesn't negotiate any other changes, I'm still for that. Because when I leave here on the 18th, I want people to say that I came here to protect people and make their lives better. I didn't come here to protect the government. Thank you.
Thank you, Senator Erdman. Senator McKinney, you're recognized to speak.
Thank you, Mr. President. I oppose the bracket motion. I support the AM and the bill. And just like Senator Erdman, I ran for office and I came to the legislature to fight for the people of my district and the people of Nebraska. And frankly, government has not worked for the people, especially not the people of my community, ever in life, ever in the history of this state. And honestly, the discussion around this bill is perplexing, to say the least. It's, let's make sure that the floodgates don't open, all these other things that is wild. You know, if a kid is hurt, we'll rather argue, let's make sure that the government doesn't lose money, essentially. If the government or a correctional officer ignores somebody saying, I am going to kill the person in my cell if you put me in there, and they do it. We don't care about that. No, we don't, because let's protect the government. Let's protect sovereign immunity. And I was just sitting back there and I'm like, are we in Russia? Are we in China? Thought this was America. You know, I thought this wasn't a dictatorship. You know, I thought we cared about the people. I thought we cared about a democracy. Greatest country in the world because American values. It's very interesting today. It really is. We care about people until the government has to be held accountable for wronging people. That is the problem. I think finding a solution on this bill and on these issues shouldn't be difficult. It shouldn't take this amount of time. When we got on this bill, I think it was like 4 or 5 o'clock. It's 9:43 right now. I don't think we should have to discuss this bill. We shouldn't have to discuss this bill this long, honestly. What is wrong with accountability? I don't care who it is. We want to do enhancements for penalties in the criminal justice system all the time. All the time. But we don't want to hold the government accountable. I don't understand it. Fair is fair. And it's just plain and simple. I believe we all were here to fight for the people of our communities, of the state. We were not here to protect the government. The government hasn't worked for the people, because if it did, we wouldn't have so many problems. Literally, we have a lot of problems because government hasn't worked. And government hasn't worked because I got a lot of reasons, you know, dating back to the origins of this country, but we don't have to get to that tonight, but it hasn't worked for a lot of reasons. And it could start at when the first slave ships came to this country, but we could go before that when people came here and took land from Native Americans. But neither here or there, we should be here trying to make sure that we're fighting for people and trying to protect people, especially kids, especially people in vulnerable positions, people that we want to say we want to hold accountable and place in these institutions. Maybe they did do something wrong, but they don't deserve to die because the government refused to listen to somebody saying, I am going to kill him if you put me in a cell, and they do it. And that person's family can't get any justice. Nothing. Government won't be held accountable. I'm just dead. Government won't be held accountable. That person's just dead. That kid's just assaulted. Nothing is going to happen. That is wrong. And there's no justification for it. And I really don't understand it. Thank you.
Thank you, Senator McKinney. Senator Lippincott, you're recognized to speak.
Thank you, sir. I'd like to yield my time to Captain Holdcroft.
Senator Holdcroft, you got 4 minutes, 52 seconds.
Thank you, Mr. President. Thank you, Senator Lippincott. Yeah, interesting, you know, the difference that's being made between people and government. I think it was Abraham Lincoln that said the government is of the people, by the people, and for the people. I don't look at government as being different from people. Government is the people. And when we try to uphold sovereign immunity for the government, that we are trying to protect the people. This opens up government to lawsuits, and who pays the price for that? Well, the people do. And that's the whole idea behind sovereign immunity, is to protect the people. So I would like to continue my testimony that came from the Attorney General. And she was the Assistant Attorney General, and she was listing just a few more things. She said, second, and related to the first, permitting these actions exposes the state to significant litigation costs and expenses, even if the state is ultimately successful. Under LB 325, no longer would these cases be decided at the outset of litigation. Instead, these types of claims would require discovery and development of the case to analyze whether the state exercised reasonable care in each of the varying scenarios, which would in many cases require expensive expert testimony. Litigating cases requires expenditure of taxpayer funds. Third, LB 325 would also compromise numerous pre-Mosher Nebraska Supreme Court decisions interpreting the meaning of arising out of an international tort language in favor of the state. This perhaps is an unintended consequence of the bill, but one we would urge the committee to consider. Fourth, as previously mentioned, the language of LB 325 would open the state up to liability for any intentional tort, which expands the type of claims for those intentional torts specifically defined in Nebraska Statute 81-8219. The phrase intentional tort is a term of art created by judges and lawyers that can include any act causing harm that was done with intent. Using the phrase intentional tort as broadly as LB 325 does could expose the state to any action where creative pleading can establish harm plus intent, including intentional infliction of emotional distress, trespass, and conversion of chattel. Last, but certainly not least, a remedy is available for these individuals. Specifically, an individual injured by an intentional tort can bring a 42 U.S.C. 1983 action against state officials who are deliberately indifferent to their duties, meaning they knew of and disregarded a substantial risk of harm in the injured person.
1 minute.
Thank you for the opportunity to testify today. I would be happy to answer any questions the committee may have. So again, there is a remedy for the victims. It's available. Specifically, an individual injured by an intentional tort can bring a 42 U.S.C. 1983 action against state officials who are deliberately indifferent to their duties, meaning they knew of and disregarded a substantial risk of harm to the injured person. I would also, we've heard this, I've heard two different things at different times from the presenters. First, it's not about the money. Okay, we're trying to hold government accountable. And then I hear it's all about the money.
Time.
Thank you, Mr. President.
Thank you, Senator Holcroft. Senator Ibach, you're recognized to speak.
Thank you, Mr. President. I would just like to say thank you to Senator Holdcroft because he has embraced this whole issue completely. And I would also, from the last two times he's been on the mic, I would just like to add that he actually hit the nail on the head. Because if a family wants accountability for a sexual abuse claim, they'd want to get the perpetrator to pay, but the perpetrator never has any money or is accountable. And Senator Halloran and I were just having the same conversation. And so because of that, because they never either have the money or the accountability, they sue the entity. And so the entity, which is the school, is stuck paying the bill. And so your school district's taxpayers, who are you and me, are always on the hook to pay the demand awarded to the family for the act of the perpetrator. And it's not fair, but that simplified, that's exactly what Senator Holdcroft just said in his last two scenarios. So anyway, nobody wants to see a kid sexually assaulted, but in my opinion, to bankrupt a public school or a city or a county is not accountability. It's totally misdirected. And so thank you, Senator Holdcroft, for outlining it so eloquently, but in simple terms, I think we all understand that the accountability should be with the perpetrator. So with that, I would yield my time to Senator Michaela Cavanaugh.
Senator Michaela Cavanaugh, you have 3 minutes and 6 seconds.
Thank you, Mr. President. Colleagues, I have a very important announcement to make. If you could all bear with me for a moment and wish our former page and now part of the clerk's office, Kate Kassing, happy birthday, because today is her birthday. And also, a couple of weeks ago, our page Maggie, who's up in the timekeeping, had her golden birthday on March 21st. Happy birthday, Maggie. Happy birthday, Kate. Thank you so much for spending your time with us. I yield my time, Mr. President.
Thank you, Senator Cavanaugh. Senator Lowe, you're recognized to speak, and this is your third and final time.
Thank you, Mr. President. I will continue. In the vast majority of new cases that LB 325 would create, we are talking about adding a civil penalty for criminal behavior that will be paid by the taxpayer instead of the criminal. It's not the government paying, it's the taxpayer. LB 325 would shift responsibility for the crime away from the perpetrator who directly caused the harm, and instead places the prospect of the civil monetary damage on the public entity having custody or control over the criminal under the theory that the public entity caused the harm indirectly. LB 325 would require public entities to hire attorneys to prove that crimes by the third parties weren't foreseeable, and if a case settles or there is a judgment, it would be paid by taxpayer dollars, not the government. Government really doesn't have dollars, they have taxpayer dollars. Little old ladies, young men and women. LB 325 because of our public employers work diligently to prevent crimes in public spaces, I believe public entities could defend and prevail in many of these new cases. But in those instances, LB 325 would be opening a new door to litigation for the sake of litigation. In other words, taxpayer dollars would be spent on litigation, but ultimately the victims of assault would not recover. Surely we can all agree that our law enforcement and corrections officers, school teachers, and others who are charged with the task of taking custody or control of people have a very difficult job. On one hand, they have the respect of the civil rights of the people they are taking into or have in their custody. For example, by being cautious about how much force they use and by making sure those in custody aren't too isolated or restricted in freedom or movement. On the other hand, LB 325 would create a potential for new civil liability and money damages if governmental employees in these settings don't do enough to prevent third persons from doing harm. How do they strike that balance? How much security is enough security to prevent harm? How much does that add security in itself cost taxpayers? How many restrictions can public entities place on people to make an environment secure enough from harm to avoid the potential civil liability that would be created under LB 325? without running afoul of prisoners and arrestees and ordinary citizens' civil rights. Further, even with best efforts at security and control, it is very difficult to foresee, predict, or stop people who may be irrational, mentally ill, or under the influence from committing crimes like assault in custodial settings and at chaotic arrest scenes. The effects and impacts of 325 are largely unknown and can't be quantified. Whenever settled law is altered, it is going to result in more mitigation, if for no other purpose than to test the waters. Thank you, Mr. President. For public entities, that means more taxpayer dollars used to defend and settle litigation, no matter which side prevails. Taxpayer dollars, little old ladies' money that they pay their taxes with. It is important to point out that in any instant where appropriate preventive measures of public employees truly fail, there has always been a federal legal remedy for victims to seek civil damages, regardless of 325. Remedy that currently exists under federal law is for civil rights violations, and it applies if a governmental supervisor or official has been deliberately indifferent to risk of assault in a custodial setting. The existing federal remedy has a 4-year statute of limitation and no cap on damages, as well as attorney fees for successful plaintiffs. This federal remedy ensures that government. Thank you.
Thank you, Senator Lowell. Senator Hughes, you're recognized to speak.
Thank you, Mr. President. I wanted to stand up, and I thought I'd read more comments that were given during the hearing for LB 341 in February of 2023. Just different ones. This was from someone from District 25. Representing themselves. I am president of the district OR1 school board in Palmyra and Bennett. These comments are my own. I oppose this bill. Under current law, any claim made against a school for child sexual abuse would fall under the political subdivision. We've done this 100 times. PSTCA. This act provides a financial cap of $1 million for liability claims made against schools. LB 341 removes sovereign immunity provided by the PSTCA and therefore eliminates the liability caps for schools. If passed, it could greatly increase the financial exposure for all political subdivisions. Currently, public schools can be sued under federal law for egregious claims regarding sexual abuse that do not have a financial cap. This bill adds additional state law financial liability with a much lower threshold and unlimited financial liability. Property taxes are already too high due to a lack of state support. We were 49th out of 50 in the United States, and we do not need any additional potential financial liability. So again, this is not protecting government. We're trying to protect the taxpayers as well. Here is another opponent representing themselves. This is from District 17. I am opposed to LB 341 that removes sovereign immunity provided by PSTCA and therefore eliminates the liability cap for all political subdivisions. Currently, there is a $1 million liability for child sexual abuse claims. If this is passed, it would greatly increase the financial exposure for all political subdivisions. Currently, public schools can be sued under the federal law for egregious claims regarding sexual abuse and do not have a financial cap. This bill adds additional state law financial liability with much lower threshold and unlimited financial liability. This one's also from someone in District 17. I had a hard time with this bill and understanding the intent. To my knowledge, and after talking to several teachers, there is not a problem in schools with teachers not being held accountable for sexual abuse of children. Schools are not protecting teachers from prosecution. I think this could also open up the state to a lot of lawsuits. It just says state agencies. That could mean if a child was sexually abused in foster care, they could sue the state. Theoretically, if the state let a child sex abuser out of jail or chose not to prosecute and be reoffended, they could sue the state. I always want to hold people accountable, but this is just another layer we possibly do not need. Also, it is being promoted by hate groups in the state for a way to hold public schools and libraries accountable, and I'm leery of that and therefore adamantly opposed. There was another one in here. Maybe. Okay, here it is, finally. This one is from District 1, representing themselves. With LB 341, schools will be forced to place more emphasis on preventing sexual abuse. Currently, there is little motivation for school to do so. They just react to incident as they happen, and then more often than not, how many cases they commit suicide, and that is how it's discovered after the fact. I think this person was a proponent. It was written wrong. Anyway, I just wanted to mention, thank you, Mr. President. Just coming from a school board again, I just think we've got the things in place. The teachers go through, teachers and staff, it's not just teachers, staff, administration go through tons of education on what to look for in these things. This is just opening up more money. It's going to cost more for insurance. And there are ways that people can sue the perpetrators of what is happening, and these perpetrators get in trouble. I just don't know that this is actually necessary. So thank you, Mr. President.
Thank you, Senator Hughes. Senator Boslin, you're recognized to speak, and this is your third and final time before closing. Senator Boslin.
What did you say? I'm sorry. Oh, thank you. Okay, so I just wanted to clarify a couple of things because Senator McKinney was discussing a very tragic situation that occurred in Tecumseh with an inmate, and among the things that occurred in that case was that someone died, and that is the situation is horrible that occurred there, and certainly I would agree that there should be some recourse for the family in that case. But Senator McKinney said that there was nothing that family could do, there was nothing they could recover, and I want to be clear with everyone that in that particular case specifically, the state did settle that case with the family because it met the threshold of this was exactly the type of case that this bill is already covered under. So in that particular case, at the penitentiary, or excuse me, at the Tecumseh Correctional Facility, two individuals were put into a cell together. The one individual had said he was going to hurt the other inmate, and tragically subsequently did do that. And in the order, the U.S. District Court Judge Lori Smith said, given Schroeder's regular placement in restrictive housing and known behavioral problems, it is plausible that Brown and Hustler, the correctional officers, were deliberately indifferent to a substantial risk of harm posed by Schroeder to Barry. And so in that particular case, one, the individual who committed that crime was held accountable for it, but also the state did settle that. So the system worked. The State Tort Claims Act worked. I found a letter in the file here that I inherited dated February 24th, 2023 from Bo Botello, who is the General Counsel for the Department of Health and Human Services. It's regarding LB 341. Good afternoon, Chairperson and members of the Judiciary Committee. My name is Bo Botello, and I am the General Counsel for the Department of Health and Human Services. I am here to testify in opposition to LB 341. The bill would impose liability on state agencies in the same manner and to the same extent as a private individual or entity under like circumstances for all claims arising out of child sexual abuse. This means that a state agency would lose its qualified immunity and could be liable under theories beyond those currently allowed under the State Tort Claims Act. It would expose state agencies liable it would expose state agencies to liability for child sexual abuse perpetrated by third parties. The bill would not require the victim to have been under the state agency's supervision or under its care, custody, and control when the abuse happened. It would not require the victim to have been under the state agency's supervision or under its care, custody, and control when the abuse happened. The taxpayers of Nebraska could be paying for the intentional wrongful acts of third parties, even when the state agency acted reasonably with due diligence and was not negligent. The welfare of children in Nebraska is tremendously important to all of us. The Department of Health and Human Services takes its obligations and service to Nebraska families seriously. LB 341 would likely increase the number of lawsuits filed against state agencies, and defending those lawsuits would be longer and more difficult. The people of Nebraska would pay the price for the intentional bad acts of other individuals. Thank you for the opportunity to testify. Happy to answer any questions. So there was another example of the testimony that was heard at the time of the hearing and was provided at the time of the hearing regarding the situation here. So with that, I will yield the rest of my time.
Thank you, Senator Bos. And Senator Wayne, you're recognized to speak.
Question. Call of the House.
Do I see 5 hands? The question is I see 5 hands? I do. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Mr. Clerk, report.
17 ayes, 1 nay to place House under call, Mr. President.
The House is under call. The House is under call. Senators, please report your presence. Those unexcused senators outside the chambers, please return to the chamber and record your presence. Unauthorized personnel, please leave the floor. The House is under call. Senator Dorn, Senator Conrad, Senator Jacobson, Senator Kauth, Senator Hardin, Senator Bosselman, Senator McDonald, Senator Erdman, Senator Dungan, Senator John Kavanaugh, please check in. The House is under call. Senator Erdman, Senator Dungan, Senator John Kavanaugh, please check in. The House is under call. Senator Dungan, Senator John Kavanaugh. All unexcused members are now present. The question is, shall debate cease? There's been a request for roll call reverse order. Mr. Clerk, please call the roll.
Senator Wishart. Yes. Voting yes. Senator Wayne. Voting yes. Senator Walls. Voting yes. Senator Von Gillern. Voting yes. Senator Vargas. Voting yes. Senator Slama. Voting yes. Senator Sanders. Voting yes, Senator Reapy. Voting no, Senator Raybold. Senator Merman. Voting yes, Senator Mosier. Senator Meyer. Voting no, Senator McKinney. Voting yes, Senator McDonald. Voting yes, Senator Lowe. Voting no, Senator Lippincott. Voting no, Senator Linehan. Voting yes, Senator Kauth. Voting no, Senator Jacobson. Not voting, Senator Ibach. Voting no, Senator Hunt. Senator Hughes. Voting no, Senator Holcroft. Voting no, Senator Hardin. Voting no, Senator Hansen. Not voting, Senator Holleran. Voting yes, Senator Frederickson. Voting yes, Senator Erdman. Voting yes, Senator Dungan. Voting yes, Senator Dover. Voting no, Senator Dorn. Voting no, Senator DeKay. Voting no, Senator DeBoer. Voting yes, Senator Day. Senator Conrad. Voting yes, Senator Clements. Not voting, Senator Michaela Kavanaugh. Voting yes, Senator John Kavanaugh. Voting yes, Senator Brewer. Voting yes, Senator Brandt. Voting yes, Senator Bostelman. Voting no, Senator Bostar. Voting yes, Senator Boston. Voting no, Senator Blood. Senator Ballard. Voting no, Senator Armendariz. Voting no, Senator Arch. Not voting, Senator Albright. Voting no, Senator Aguilar. Vote is 22 ayes, 17 nays, Mr. President, to cease debate.
Debate does not cease. I raise the call. Senator Lippincott, you're recognized to speak.
Thank you, sir. I yield my time to Captain Holcroft.
Senator Holcroft, you have 4 minutes and 50 seconds.
Thank you, Mr. President. Thank you, Senator Lippincott. I'd like to start off talking about accountability. And I have some experience with accountability with 28 years in the Navy. And so the big question is, how do we hold people accountable for their actions? This bill says you sue them, and it's all about the money to make the victim whole. It doesn't necessarily fix the issue. The premise, the argument is, if they're subject to being sued and they're threatened by large amounts of settlement, then they'll fix things. But the problem is, it's not their money. It's the taxpayers' money. And if they get sued and have to pay out, probably the insurance company will pay. If you want to hold somebody accountable, you need to put some other mechanism in place to hold individuals accountable. And in this case, you would fire them, or you would increase their training, or because frankly, people make mistakes, and not intentionally. No one wants, except for the perpetrator, no one wants to hurt a child. And so, to me, opening up these organizations to large numbers of suit, even as $2.5 million, it's not the right thing to do. It's not the solution. The solution should be to put mechanisms in place to ensure that we don't let this happen again. So I have more to read, but I would like to talk about accountability from a Navy service perspective, and tell a few sea stories, I guess. So, to be a commanding officer of a ship, of a destroyer, it takes about 20 years. It takes about 20 years of that's when people rise to the rank sufficient for command at sea, and that's the goal of every naval officer, is command at sea, whether it is command of a ship, whether it's a command of a submarine, whether it's a command of an air squadron or an aircraft carrier, and that's what we really strive for. And to get there, it takes a lot of experience. It takes about 10 years worth of experience aboard ships. So when you join the Navy, you don't always you're not always assigned to a ship. They let you go ashore for a couple of years, and then you go back to a ship and then back to shore. And at each step, you take on more responsibility and you have more authority. And eventually, hopefully, you'll get up to command of a destroyer. And typically, that is about the top 4% of a year group. That's what it takes. I mean, it's a pretty steep pyramid. You start aboard your first ship as a junior officer. There's probably between 20, 25 junior officers, and then the next level of the pyramid is 4 department heads. So it's pretty steep there. And then there's 1 XO and there's 1 CO. But the CO is really responsible for everything that happens aboard the ship, and that's where accountability is ultimately. And when you're the CO and you're underway.
1 minute.
Thank you, Mr. President. You are making all the decisions. Once you get away from the pier and you get out to sea, there's no fire department to respond. There's no police department to respond. You're cooking your own meals. You're making way through the ship, and ultimately, the CO is responsible for the training and the performance of its crew. And the Navy holds them to a very high standard. And if they mess up, the punishment is swift and unforgiving. A collision at sea, running aground, that CO is immediately relieved. There's no investigation because there's absolutely no reason why a ship should run into another ship or should run aground, because the CO is not doing his job if that happens, and that CO is done.
Time.
Thank you, Mr. President.
Thank you, Senator Holcroft. Senator Armendariz, you're recognized to speak.
Thank you, Mr. President. Speaking from experience, a child that's been abused is never made whole with money or a check. What we're talking about here is really making people accountable for their actions. So let's think about how we do that in private institutions or retail environments, or even nonprofits such as churches. We get the choice, if there have been bad actors, we get the choice to patronize that business, to participate in that church or institution. And if they're found to be bad actors, we can leave with our money. And that has been proven to be extremely effective in causing change. That is why this is so different. If somebody is abusing my child, and they go to a public school, I'm still forced to pay for that public school. Maybe even forced to pay more for that public school because of lawsuits. I don't get a choice. That's what makes this so different than any other way we sue institutions that are doing wrong. Until you give me a choice to move my child and pay for it, I'm a no on this bill. I need to have that choice as a taxpayer to not fund an institution that is doing bad. With that, I would like to offer the rest of my time to Senator Boson if she'll have it.
Senator Boson, you're yielded 3 minutes and 5 seconds.
Thank you. Thank you, Mr. President and Senator Armendariz. Okay, I'll go back to my letter from February 23rd from the Nebraska Association of County Officials. This was a letter from their legal counsel, Elaine Menzel. I had started reading it and then realized I was going to run out of time. So A 2019 report on the Federal Tort Claims Act from the Congressional Research Office stated, empowering plaintiffs to sue can ensure that persons injured by employees receive compensation and justice. However, waiving the government's immunity from tort litigation comes at a significant cost. The U.S. Department of Treasury's Bureau of the Fiscal Service reports that the United States spends hundreds of millions of dollars annually to pay tort claims under the FTCA. Federal Tort Claims Act. And the Department of Justice reports that it handles thousands of tort claims filed against the United States each year. Moreover, exposing the United States to tort liability arguably creates a risk that government officials may inappropriately base their decisions, quote, not on the relevant and applicable policy objectives that should be governing the execution of their authority, but rather on a desire to reduce the government's, quote, possible exposure to substantial civil liability. That end quote for all of the report. Similarly, empowering plaintiffs to sue political subdivisions such as counties, municipalities, schools, etc., in additional situations comes at a significant cost, including possible substantial civil liability exposure, possible monetary costs due to damages, etc.
1 minute.
Thank you. Additional concerns that arise due to provisions included within LB 341, the removal of statutory recoverable damage limits, notice provisions, statute of limitations, and jury trials. To expound on why the one-year notification provision is beneficial under the Political Subdivision Tort Claims Act, the court in Campbell versus City of Lincoln, which is a case from 1976, said, the tax-paying public has an interest in seeing that prompt and thorough investigation of claims is made where a political subdivision is involved. The public does not have such an interest as to claims against private persons or corporations. The taxpayers who can provide the public treasury with funds have an interest in protecting that treasury from stale claims. I'll conclude my time on that and finish the later if I have more time. Thank you.
Thank you, Senator Armendariz and Senator Boz, and Senator Clements, you're recognized to speak.
Thank you, Mr. Chairman. I would like to ask Senator Holdcroft a question.
Senator Holdcroft, would you yield to a question?
Yes.
Senator Holdcroft, I was looking up LB 325 and don't see any committee statement. Could you tell me what action did the committee, has there been any action in the committee on LB 325?
Yes, I think we've exec on it at least twice, possibly 3 times, and each time it's been a 4-4 vote. So it's not come out of committee.
All right, so, right, it was a stalemate, so it hasn't moved out of committee. It's still in committee, right?
That's correct.
All right, thank you. I heard Senator Bozen needed some more time, I believe. So I'll yield the rest of my time to her.
Senator Bozen, you have 3 minutes and 55 seconds.
Thank you, Senator Clements. So I'll finish my letter from the legal counsel, Elaine Menzel, for the Nebraska Association of County Officials, and this letter is regarding LB 341. So it says, through enactment of the Political Subdivision Tort Claims Act and the State Tort Claims Act, the legislature has allowed a limited waiver of sovereign immunity with respect to some, but not all, types of tort claims. Both the STCA and the PSTCA expressly exempt certain claims from the limited waiver of sovereign immunity. We ask that you not expand the additional liability exposure to political subdivisions under a new act that would not contain the guidelines currently provided under the PSTCA. LB 341 would significantly weaken the original intent of using the structure of the Political Subdivision Tort Claims Act to govern the methodology in which political subdivisions are responsible for torts. Further, LB 341 would enhance the litigation exposure to political subdivisions, including counties. She then goes on to conclude her letter. I also have a letter here dated February 23rd, 2023 from the same individual as it relates to LB 325. That is Senator Duncan's bill to change immunity for intentional torts under the Political Subdivision Tort Claims Act and the State Tort Claims Act. Dear Chairman Wayne, on behalf of the Nebraska Association of County Officials, we appreciate the opportunity to appear before you in opposition to LB 325, which would expand the scope of liabilities to counties beyond what has ever been permitted in Nebraska. It would allow claims to proceed, quote, when the harm caused by an intentional tort is a proximate result of the failure of a political subdivision or an employee of the political subdivision to exercise reasonable care to either, one, control a person over whom it has taken charge, or two, protect a person who is in the political subdivision's care, custody, or control from harm caused by a non-employee actor. The legislature has proclaimed its intent under the Political Subdivisions Tort Claims Act in Nebraska Revised Statutes, Chapter 13, Section 902, that provides in part, quote, no political subdivision shall be liable for the torts of its officers, agents, or employees, and that no suit shall be maintained against such political subdivision or its officers, agents, or employees on any tort claim except to the extent and only to the extent provided by the Political Subdivision Tort Claims Act. The legislature further declares that it is
1 minute.
Thank you, intent and purpose through this enactment to provide uniform procedures for the bringing of tort claims against all political subdivisions, whether engaging in governmental or proprietary functions, and that the procedures provided by the Act shall be used to the exclusion of all others. Under common law, prior to the adoption of the PSTCA, the court explained, this court long ago adopted the traditional common law view that a public entity engaged in governmental activities is not liable for negligence. Immunity has been based upon a public policy which subordinates mere private interests to the welfare of the general public. That case is Brown versus City of Omaha from 1968. I'll finish there because I know I must be almost out of time. Thank you, Mr. President.
Thank you, Senator Clements, Holcroft, and Boson. Senator Conrad, you're recognized to speak. The question's been called. Do I see 5 hands? I do. The question is, shall debate cease? All those in favor vote aye. All opposed vote nay. Been a request to place the House under call. Shall the House go under call? All those in favor vote aye. All those opposed vote nay. Report, Mr. Clerk.
22 ayes, 5 nays. Place House under call, Mr. President.
The House is under call. Senators, please report your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Hughes, Wayne, please check in. All unexcused members are present. The question is a roll call vote in reverse order. The question is, please cease debate. Call the roll.
Senator Wishart. Voting yes. Senator Wayne. Voting yes. Senator Walls. Voting yes. Senator Von Gillern. Voting yes. Senator Vargas. Voting yes. Senator Slama. Voting yes. Senator Sanders. Voting yes. Senator Reapy. Not voting. Senator Raybold. Senator Merman. Voting yes. Senator Mosier. Senator Meyer. Not voting. Senator McKinney. Voting yes. Senator McDonald. Voting yes. Senator Lowe. Voting no. Senator Lippincott. Voting no. Senator Linehan. Voting yes. Senator Kauth. Voting no. Senator Jacobson. Voting yes. Senator Ibach. Voting yes. Senator Hunt. Senator Hughes. Voting no. Senator Holcroft. Voting no. Senator Hardin. Voting no. Senator Hansen. Voting yes. Senator Holleran. Voting yes. Senator Frederickson. Voting yes. Senator Erdman. Voting yes. Senator Dungan. Voting yes. Senator Dover. Voting no. Senator Dorn. Voting yes. Senator DeKay.
No.
Voting no. Senator DeBoer. Voting yes. Senator Day. Senator Conrad. Voting yes. Senator Clements. Not voting. Senator Michaela Kavanaugh. Voting yes. Senator John Kavanaugh. Voting yes. Senator Brewer. Voting yes. Senator Brandt. Voting yes. Senator Bostelman. Voting no. Senator Bostar. Voting yes. Senator Bosson. Voting no. Senator Blood. Senator Ballard. Voting no. Senator Armendariz. Voting no. Senator Arch. Voting yes. Senator Albright. Voting no. Senator Aguilar. Vote is 27 ayes, 13 nays, Mr. President, to cease debate.
The debate does cease. Senator Bosin, you're recognized to close on your bracket of motion.
Thank you, Mr. President. I would ask that we vote green on the bracket motion to bracket this. It does not appear we're going to have a consensus, and if we bracket it, we can save ourselves the next 3 hours of general file debate. Vote green.
Thank you, Senator Bosin. The question is? The motion to bracket the bill. All those in favor vote aye. All those opposed vote nay. All voted who care to. Record, Mr. Clerk.
19 ayes, 19 nays to bracket the bill, Mr. President.
The motion fails. I raise the call. Mr. Clerk for items.
Mr. President, Senator DeBoer would move to reconsider the vote just taken on MO 1282.
Senator DeBoer, you're recognized to open.
Thank you, Mr. President. I would like to withdraw.
Without objection, so ordered. Mr. Clerk, next item.
Mr. President, Senator Boston would move to recommit the bill to the Judiciary Committee.
Senator Boston, you're recognized to open.
Thank you, Mr. President. Excuse me. I rise once again in opposition of the bill. and ask that we recommit this to committee. I will finish reading my letter from Elaine Menzel on LB 325. Not long after the Brown case was decided, the PSTCA was adopted in 1969. The State Tort Claims Act and the Political Tort Claims Act were the result of an interim study committee created by the legislature. Both acts were patterned after Iowa statutes and the Federal Tort Claims Act. In Weber versus Anderson, which is a 1971 case, which appears to be the first case decided by the Nebraska Supreme Court after the legislature adopted the Political Subdivisions Tort Claims Act in 1969, the court addressed the intentional tort exemption by stating in part, quote, "It is quite apparent that this court has not wiped out the full scope of the doctrine of governmental immunity. It has attempted only to eliminate government immunity in certain areas and then only until such time as the legislature occupies the field. We are therefore faced with the problem whether or not the abrogation of the doctrine of governmental immunity should be extended to actions for false arrest, false imprisonment, and libel and slander. We conclude that the governmental immunity should be and is a defense to these types of actions. We are influenced by the fact that this is the proper public policy to be adopted because of the enactment in 1969 by the legislature of a Political Subdivisions Tort Claims Act prohibiting tort claims, quote, except to the extent and only to the extent provided by this act, end quote. Through enactment of the Political Subdivisions Tort Claims Act and the State Tort Claims Act, the legislature has allowed a limited waiver of sovereign immunity with respect to some but not all types of tort claims. Both the State Tort Claims Act and the Political Subdivisions Tort Claims Act expressly exempt certain claims from the limited waiver of sovereign immunity. We ask that you not expand the current exemptions under the PSTCA, as LB 325 would do by significantly weakening the original intent of the intentional tort exemption under the law. It creates significantly heightened litigation exposure and costs for governmental entities such as counties. We encourage you to oppose LB 325 by voting to IPP. Thank you for your consideration to these comments. So again, we've got, I was told there was a motion that removed LB 25 in its amended form. I haven't seen it, but I venture to believe that it's true. So that would leave the two bills that have been filed to LB 25 to be LB 325 and LB 341. LB 325 still in committee. We've talked about that ad nauseum. That is still in committee. It was voted on not once but twice, and according to Senator Holdcroft, potentially 3 times, and is still in committee. 341 was voted out of committee, and I rise in opposition to that bill. I think that that bill creates more problems than anyone here thinks it solves. If there are ways that we need to enhance security at schools for our children, I am all in. So we can have those conversations. But this bill will not do that. And I would submit that I believe it does the opposite of that. And so I am asking that we recommit these bills back to the committee so we can have an actual vote on them coming out of committee and that we can work out the kinks that there are in LB 341. Thank you, Mr. President.
Thank you, Senator Boslin. Mr. Clerk, for items.
Mr. President, amendments to be printed from Senator McKinney to LB 164A, Senator Michaela Kavanaugh to LB 1300, Senator Lowe to LB 25, Senator Wayne to LB 25, Senator Holdcroft to LB 25, Lowe, Kouth, Wayne, Holdcroft to LB 25. Amendments to be printed from Senator Walls to LB 358A, Senator Bostar to LB 874. Finally, Mr. President, a priority motion. Senator Lowe would move to adjourn the body until Friday, April 5th, 2024 at 9:00 a.m.
The question is, shall the legislature adjourn? All those in favor say aye. All those opposed say nay. The question is, shall we adjourn? All those in favor vote aye. All those opposed vote nay. Mr. Clerk, record, please.
22 ayes, 13 nays to adjourn, Mr. President.
We are adjourned.